May I mention a death row matter, Your Lordship? He's been a death row matter. He's been incarcerated for more than 30 years. He's been on the death row for about 19 years. I'm requesting for listing, Your Lordship. It is to be listed before a 3-judge bench. We had moved an early hearing application in which an order was passed.
Give the particular.
Yes, Your Lordship. Your Lordship is also sitting in a 3-judge bench this week, Your Lordship.
My lords,
Much obliged. Much
may I mention item 25, my lords. This is a bunch of civil appeals. Mr. Kapil Sibal is leading Meta Platforms in the matter. He's taken ill, so we are seeking an accommodation of another week, my lords.
Just give your note, please.
In fact, my lords, I am also mentioning on behalf of Mr. Kapil Sibal for a matter which is.
We have informed.
In the Meta matter.
Mr. Sibal is not well. He spoke to me. He is unable to speak.
No objection. No, obviously no.
Do you want to be taken up today?
But it's listed today. He is mentioning it not for next week. Sibal is not.
Well, if none of you have any objection, you can take up next week.
I've also filed an intervention application on behalf of All India Small Industries Forum, because we are all using WhatsApp business accounts. So we have got to say something.
You are
4 crore users are there.
You are seeking improvement in that.
Yes.
If there are no objection, we can improve. You
But
are
that WhatsApp business is very important.
like application for say ISO and so and so allowed to the extent that the applicants are permitted to intervene and assist this court.
Yeah.
The short affidavit can be filed within by Friday.
The lordship is listed not Friday week.
We are also like
He cannot come not for a week, 10 days. So not Friday week, not this Friday, but next Friday.
The 20th.
Also.
20th. If it pleases the court.
Then should we take up on 23rd, Monday?
No problem.
Very well.
And beyond 24th, then because too many SLPs will be there. That's why I'm suggesting.
23rd, the only advantage Monday is miscellaneous day.
And your
So
lordship,
at least
So let it come on a Monday, then your lordship take a call.
because your lordship has listed this only for.
we will accommodate you. If you are busy in the other course, we will accommodate us.
That's it.
And your lordship has listed right now only for consideration of interim. For
Correct.
your lordship has given another date.
Correct.
So, what is the main date in the main case then?
Your lordship has given it April.
Yes.
15th April in the main matter. In the main.
So 23rd we will only put that.
Consider period on 23rd.
Whatever proceedings were to take place today, those will now take place on 23rd February. That's all.
Obliged.
With your permission.
With your permission, my lords, may I mention item number 33 in tomorrow's list, my lords. Same Mr. Sibal is appearing and he's he's not well and will be seeking.
What happened to Mr. Sibal yesterday, the day before?
He's not well and I think he won't be, it's like very bad viral fever he has got and.
Because of the change of weather or might be.
Yes, my
Yesterday
lord.
I saw him appearing in some function, you were there. So I just thought that he's fit and fine.
No, he is.
But anyway, that throat problem, he must take some rest.
Yes, my lords. My lords, I've informed the other side. It's for listed for tomorrow, my lords. I'll be seeking an adjournment.
The lawyer's problem is otherwise. They are good, but they speak too much.
Yes, my lords. That's also the.
A silent threat for a lawyer
My
may
lords.
can become the cause of ailment.
Well, just one request. This matter has been pending for substantial amount of time.
Please
And the
come on.
process has,
Promises to him for, we pray for his speedy recovery. Thought is something that, yes, one has to take rest. There is no way out of it.
Yes, my lords.
well, it's just a simple request. If a short date can be given, the matter has been posted for long. And I'm appearing in this matter, ma'am.
This very matter.
Yes.
In this very matter, we have informed
Just
him.
a small request.
Oh,
If
you are
this matter
opposing.
can be taken up on a short date.
Are you opposing?
Yes, my lord.
No, she's not opposing.
I'm opposing just if this can be kept for a short date.
But you are opposing a longer date.
Sorry, my
What are you opposing then?
well, I was not opposing. I'm just simply putting a request. If my lords can consider to put it on a short date.
We can accommodate you with the date of your choice, that's all.
Yes, my lords.
Provided that we too have some space on that day. If already there are sufficient matter listed, then there is no use of adjourning condition.
Yes, my lord.
Keep on waiting whole date and might not come. So have a date when we can also accommodate you. Give a shortest date.
With your
Obliged.
permission, Lordship,
Obliged.
please mention WP Civil 13381 MC Mehta matter. I am the applicant in that matter. I have filed my compliance affidavit with
Sir,
the court.
MC matter I can't take up every day. But I have fixed a schedule. It will be taken up and all the pending applications we are taking one by one.
Your Lordship, the project is getting delayed. I have filed my
So
compliance
like,
affidavit.
make out a case of urgency, we will take up. When we list the MC matter, then we also see that how the IAs or MAs are to be prioritized. We do that homework and then only we list it. So we'll see that if.
Lordship, it is a Taj related matter situated in.
Thank you very much. We will give it.
My lords, in the same,
Mention you have,
my lords, in the same matter, the difficulty is that my application for the
you
army,
are making the same mentioning, then why keep mentioning?
my lords, the application is different. I'm representing army.
All right, thank you. We are listing MC Mehta. Will not.
My lord, just a humble request, my lords, the date was showing like 10th, 9th and 10th, but it was not listed. My lords may fix a date and my lords,
Whatever the reason, whatever the ground, we will see it when to be listed. Thank you. Thank you very much.
My lord, may I mention one matter which is very urgent? My lord, while I was appearing on the last Saturday in the Tis Hazari court, in the court of ADJ Harjit Singh Pal, in the court of ADJ Harjit Singh Pal, where I was appearing on behalf of the accused, and my lord, the opponent, the complainant's advocate, along with many goons, entered into the courtroom. In front of the judge itself, they immobilized me, hit me, and all the accused inside the court were two.
Hit you as a counsel or they hit the.
I was a counsel. I was a counsel of the accused person.
You were assaulted.
I was also assaulted along with the accused person also assaulted. And thereafter, they locked the door inside the courtroom. Judge was sitting right there. All the members of the courtrooms were there. Police officials were there.
You are bringing this matter to, when it happened?
Last Saturday on the 7th.
On Saturday. That means day before.
Day before, my lord.
Today is Monday.
Today is
Have you brought to the notice of the Chief Justice of Delhi High Court?
No, my lord. Actually, nobody is supporting. Police is so scared. They are not even ready to provide
Forget
the
about this.
security.
If you can make mention before me, why haven't you made mention before the head of the state judiciary, Chief Justice of the Delhi High Court?
My lord, I have seen that due to the past incidents in the Tis Hazari, nobody is touching this matter because it is against. So I am the member of the Supreme Court Bar Association.
Are you making mentioning so that media can catch up it?
No, my lord.
Then have you made any written complaint to me?
No, my lord, this is written.
Please go make a written complaint to the Chief Justice of the Delhi High Court during the course of day and send a copy to me, inform my PPS that you have made a complaint, then let me deal with that administrative.
My lord.
Nothing to be done on judicial side. I will deal with it. But first you go and make a complaint. Let the Chief Justice take cognizance of it.
My lord.
If the police is not, that means that there is no rule of law. You make a complaint, give a copy to me and tell the staff that you have made a complaint there.
My lord.
How can they misbehave like this? This kind of Gundaraj Kant is not acceptable to us. Go and make a complaint immediately to the High Court. Yes, let us start.
May it please your lordship, may I request your lordship may take up the paper book of item 20, which is a.
Yes, item 1, 20 and 41 are same.
Your lordship, may I the paper book of item 20, because this is a case where.
We have already discussed it. No. Notice in a similar matter, issue notice. What is the next date in that matter? It was on 29th January.
20 is also
It is
listed
in
today.
fact listed.
It is listed today, my lord.
Today.
Item 20.
All the pleadings are completed.
It is item
pleadings-
12.
Yes, my lord, because,
Are you kidding?
yes,
So then please, would like to file any counter in that matter or what?
we have, all the pleadings are completed from all sides. And my lord, in fact, we are ready with the note.
So then we'll take up this matter along with item 12.
So notices will have to go in item number 1, 1.1, 1.2, 1.3.
My lord, issue is one and the same.
1.
Issue is one and the
Issue is
same,
the
my lord,
same.
of all the matters, 1 and 20 and 41. It is only, my lord, 2023 notification of.
Issue is very simple, that even if it pertains to the recruitment of judicial services, can the High Court assume the role of the subject experts? That is the issue.
And the-
Am I right?
That is one. That is one, my lord. Number two, my lord, when the High
Nothing like number 2, only number 1.
High Court is 134 is the total control of the entire judiciary recruitment and malad. Then how the my lord, Public Service
So
Commission is agreed.
if you are learned judge, suppose he masters in mathematics, and tomorrow the question of some mathematics question comes, why you should not review that also? Because he knows that subject, like law. The other brother or sisters can be maybe that he is BSc in biochemistry. So one question of biochemistry may come. Why not that also? Because he is a high court judge.
A question of law, constitutional issue, my lord, now we are.
So we are only on the question of law. If you want us, we can remand the case to the High Court. If you want us to decide, we will decide it. But we have hinted you what is the question in our mind.
Your lordship, my prayer would be.
अरे भाई आपकी फेवर में बोल रहे हैं ना अभी तक तो आप थोड़ी 2 मिनट चुप रहिए. So sir, please guide us. What is to be done?
It can be heard, my lord, my lords may.
We have heard it. You answer it. Question is very simple. That under the law
Yes.
and whatever the precedents this court has laid down, should the court assume the role of super examiner
My lord, it is like this. My lord, the,
only on the presumption
Yes.
or assumption that the question paper pertains to law, recruitment pertains to judicial services, and therefore the High Court, as anybody would like to assume and presume, High Court is in a well equipped as compared to the examiners. If this is the principle you want to lay down as, then sir, it becomes very dangerous.
my lord, it is the Public Service Commission, my lord, after issuing the revised key, my lord, sent it to my lord
The High Court
administrative
can always
side.
say, the High Court can always say that this question seems to be incorrect, the answer key, and therefore we refer the matter back to the Public Service Commission. Public Service Commission may constitute another independent body of experts. They may revisit it. This is the only law.
Your lordship. Your lordship.
This is the legal principle well settled.
Your lordship.
If you want, we can do it immediately. That's not because unnecessarily, otherwise it will delay unnecessarily.
Lordship is
All right, right. दोनों item का है? Item 12.
Your lordship.
Lordship, there is an intervention application in this matter, item 20. Counsel is appearing online, Lordships.
Content.
Is my lord referring it to independent committee?
Independent of this.
It can be closed? Matter can be.
Lordships,
Yes.
Lordships, there is an intervention application on behalf of High
We
Court.
are allowing High Court on behalf of the High Court.
High Court of Jharkhand, kindly, and counsel is appearing
All
on.
right, all right. You are the counsel before us. You argue.
Lordships,
We are a bit conservative. We are not very fond of online, so you argue. No. Give the mic. Give the mic to the young lady.
Lordships, there is an intervention application on behalf of Honorable High Court of Jharkhand. Honorable High Court of Jharkhand is a necessary party in this matter, Lordships, as the answer key was finalized from the High Court of Jharkhand for the judiciary examination, which is in dispute, Your Lordships. So kindly allow Your Lordships to High Court of Jharkhand to become a party in this petition, Your Lordships.
So if the answer key was prepared by the High Court, in that case, the direction can be to both to the High Court as well as to the Public Service Commission. Both will examine it. Both will revisit it. And the High Court as a neutral umpire should be in the middle, not on left side or on the right side. Because courts are normally always on the right side, they are never on the wrong side. But in such like matter where you are a litigant, it is always ideal that you are the neutral umpire in between.
Obliged. Kindly make us a party, Your Lordship.
But are you right? This is the legal position.
Yes, Your Lordship.
Do you agree with the observations tentatively we are making with respect to the settled principle of law on this subject?
Your Lordship, High Court will make its submission in due.
We will say High Court has also been heard. ये allow कर दो भैया I335854 allowed. The High Court, you want respondent or you want petitioner? You want a respondent.
Precisely, that is the difficult part.
So you said middle point here.
High Court is not saying anything on administrative side. Well, in fact, on administrative side.
Marcus. Say, IAS once you allowed, the High Court of Jharkhand, through its Registrar General, is ordered to be included as respondent number 1A. Pursue, both are stage 1 and 2. Then say 2A as respondent number 2A. Say leave granted. The issue that calls for consideration is whether the High Court of Jharkhand, in exercise of its power of judicial review, rightly interfered in the key, answer key, published on 13 May 2024 in relation to, for the answer key of the preliminary entrance test held on 10th March 2024 for recruitment of civil judges in bracket junior division. The aforesaid preliminary examination was held pursuant to advertise number 22/2023 dated 14th August 2023. How many? 3 questions or more?
Yes, 3 questions. Question 8, question 74. Well, in fact, I have prepared everything, notes and the dates and events, and lots of places where I'll finish.
The High Court, through the impugned judgment, has opined that answer key in relation to question number 8,
74 and 96.
question number 74
And 96.
and 96 was erroneous and as such
And paragraph 36. Paragraph 36. It is not there in your any question. And it may- May furnish.
the impugned judgment, has concluded in para 33 that the key answer given by the appellant published distribution to questions number 874 and booklet capital A are incorrect.
26.
The High Court has directed to give 1 mark to the candidates who answered to option in bracket capital A in question number 8 in booklet A and delete question number 74 and question number 17 and 96 in booklet A from consideration. Next paragraph. The High Court, however, while the impugn judgment has held that in the absence of an express provision in a statute, rule or regulations governing the examination, re-evaluation of the answer sheet is impermissible. Next paragraph. We have heard Honorable Counsel for the Appellant Public Service Commission, Honorable Counsel for the High Court, as well as the Honorable Counsel appearing on behalf of the candidates who approach the High Court under its jurisdiction. Next paragraph. It may be true that the subject to examination pertain to recruitment to judicial services, and as such the honorable judges of the High Court, in the very fact, keeping in view their vast experience on bar and bench, are expected to have a better understanding and appreciation of the legal, the questions that were put to the candidates in the examination. However, even while accepting it as an undisputed fact, the question remains that the power of judicial review in the matter of re-evaluation, re-appreciation or reconsideration of the answer key would apply uniformly irrespective of the nature of examination. In this regard, it seems to us that the High Court cannot assume the role of super examiner, stroke subject expert, and such an exercise would ordinarily be left to the domain experts. It appears from next paragraph. It appears from the stand taken on behalf of the Public Service Commission is that the answer key, while duly vetted by the High Court on administrative side, it may or may not be side also. If that is so, it is more than necessary that the High Court, while exercising judicial power, ought to have referred the matter to the Committee of the High Court as well as to the Public Service Commission to constitute another committee of subject experts, enabling such experts to revisit the answer key in respect of question number so and so and so.
May include one professor.
High Court ought not to have taken this responsibility onto itself while exercising the power of judicial review. Consequently, we allow this appeal in part to the extent that paragraph 33 and 36 of the impugned judgment, 36 and other operative part of the judgment is set aside. However, the High Court has rightly restated the settled legal position that there cannot be re-evaluation of an answer sheet unless the rules, regulations, or policy expressly provide so. Then, for the reasons stated, we allow this appeal in part and set aside paragraph 33, 36, and other operative parts of the impugned judgment matter is referred to the committee constituted by the High Court on the administrative side to re-examine the answer key in respect of the disputed questions, and thereafter disputed questions and send its opinion to the public service commission for necessary follow-up action. The needful shall be done within 2 weeks. Next paragraph. It is clarified that we have not expressed any opinion on merits of the disputed question or the answer key.
May I only make a request where your lordships have indicated para 36. My lords may kindly include para 39 also.
No. When you said so, other property, but you can 33, 36, 39 or any other.
Obliged to.
The
This will apply to item 1, 20 and 41.
committee may consist of a professor and also subject expert on law.
जहाँ पे committee लिखा है ना, the committee may also associate some eminent law professors as domain experts for its assistance and guidance.
Because the entire contention is one of the counters says that judges are not experts in English, so they are experts only in law. I also say expert on English side, also a professor in English side, because they say all the boys was in the room. This
one question pertains to
more than one boy.
You said subject experts, so that will include the English.
Well, they may not, your lordship may say English because they
Specific expert in bracket, one of whom will be a professor in English.
deeply.
One of whom will be a
So
professor in English.
because already 2.5 years, my lords, already 2.5, my
That's
lords,
why we have said 2 weeks. We are only giving 2 weeks. And we request the High Court to conclude the pending selection process expeditiously.
my lord may say the process of the entire recruitment, because my lord, from September,
Same word we have said recruitment process. They are saying process of recruitment.
the entire process of recruitment.
Entire
Well, maybe by 3 months.
High Court and
Because subordinate judiciary, they don't have from 2.5 years, there is no appointment. Already in 2023, it was 138. 2024, 25,
my worry is entirely different. That is one High Court where there is no elevation from the bar since 2017.
larger issue.
And neither any designation methods.
Deeply well.
Yes, item 2. I think similar matter is pending, madam.
Yes, my lords.
But you are coming after such a long delay. Notice, issue notice returnable on so and so date, notice reconvention delay. Then after convention delay, or tag with SLP civil diary number 28480 of 2025.
Obliged, ma'am.
Lordship, after the election has been declared, the date of election has been declared, substantive rules have been sought to be withdrawn.
What is that change in rule? What is that change in rule?
Yes, Lordship. Lordship, you kindly have page 80. Page 80 is a reproduction of the rules of Bar Council of India uniform rules. Now, this is an extract.
It's a mistake, it was not mentioned, so it is not a change of rule. The rule was already existing.
Kindly
All right, thank you. Anything?
point out, Lordship, what's the difficulty
Yes,
here,
sir.
Lordship? Lordship, will kindly have page 80. Page 80 is the rule, reproduction of the rule.
Yes.
16. it says that returning officer shall reject the nomination paper of any person who were or are office bearers of any bar association on the date of notification of the election. Now, this was the rule. Now, after that, on 17th of January, Lordship, you'll find page 81. They sought to withdraw the rules. Now, Lordship finds what is the mandate of the election officer. The mandate which was, which the court directed was to conduct the elections and to facilitate
Why that was withdrawn? Because the notification is as per 2023 rule. The rule that was in.
I'm sorry, Lordship.
Come to page 76.
23.
Come to page 76.
Yes.
Read the first line.
Yes. Notice is hereby given under Bar Council of India rules for qualification, disqualification and produce for election and so, see, this was notification, Lordship, was not stipulate.
Sir, the notification is in terms of the latter rules. By mistake and clause of the earlier rule which stood over supervened by these latter rules was incorporated. This error was corrected. This is not changing the rules.
Please consider, Lordship. Please consider for one moment, Lordship. 23 rules did not stipulate this condition.
That
This was in the 2016 rules.
correct. 2016 rule has been overridden by the 23 rules. So, the notification having been issued under the 23 rule by incorrectly referred to 22 rules, that was corrected by the corrigendum. Where is the change of
So
rules?
Lordship will at least consider, Lordship, that
Nothing.
after the election was
Okay, thank you very
notified.
much. No question to be made out dismissed. Item 4, the letter circulated.
Please, Lordship.
In item 5, my lords, the Maharashtra Pollution Control Board, my lords,
Hmm.
issues us a direction to undertake the assessment, my lords, the damage assessment for a accident that had happened at our premises.
Yes.
My lords, in terms of that direction, they only give us 3 institutes where we could go and get the damage assessment from. One was Navy, IIT or VSI. We go to VSI and in terms of this direction, we appoint VSI for the purposes of.
So one of the expert body has assessed the damage, sir. We are not the mathematician or we are not the super experts here.
No, my lords,
An expert body, all of you agreed that there are 3 institutions of prominence who can do it. One of them has been picked up by the tribunal, assessment has been made, lossy accident you don't deny, the crisis spread it over so many areas, spoiled the
Yes.
agricultural land, that is also an admitted fact.
Well, subsequently, may I just say, my lords, 2 points. Subsequently, my lords, there is a joint committee report of the Pollution Control Board itself, which shows that I have done the remediation work at there, my lords, in the area, my lords. I have done substantial compliance of the remediation of the accident, my lords.
Yes, sir.
Thereafter, my lords, the expert authority or the expert body goes, all I am saying is, my lords, the sampling was not in terms of section 21, my lords. Please, sorry.
Follow the guidelines and then only assess.
Lords, those guidelines also, my lords, do not ask them to take away section 21 of the Water Act, my lords.
Yes.
All I am saying.
You have been given opportunity by letter dated 23/2/2023, after the samples were collected on 5th and 6th of February,
Please.
notifying you, if you wanted one of the samples to be sent to the central laboratory, you could have. You have missed the opportunity, now
No, lords,
cannot
all I
done.
am saying is the sampling was not done in accordance with law.
It was done in accordance with law. The only thing is,
Please.
your case under 21(2), 21(3),
Please.
you had an option to send one of the samples to the central water laboratory or the state water laboratory. You were intimated of the drawing of samples. You were intimated of the fact that this specialized body, which was chosen by you, was analyzing. You did not opt out
The water-
of that.
Show the conclusion of the body, my lords, just for a minute, my lords, just one page, my lords. Just if your lordships would kindly come to page 200, my lords. And if my lords may kindly see at the bottom of 200, they have given a finding in my favor, my lords, of the water.
The authorities will consider that.
No, my lords, but with that, my lords, they have also imposed a damage assessment of 2 crores, which will now.
Very right action. That this immediately.
Remediation being done, my lords.
Remediation and environmental damage costs are different, sir.
Because we have completed the entire remediation. If your lordships will come to page 200, at 200, the report gives a finding that the sampling has been done and it is correct, my lords, and there is no difficulty in that. The entire remediation has been mitigated, my lords. That's the finding, my lords. Only on this point I was before.
Let's not, because we will also know our scope of interference in the law.
Lords, may I then just request, my lords, this may not come in my way to raise the challenge because they are still considering the report on the next date of hearing. Because as far as the amount calculation of 2 crores is concerned, my lords,
That
there
is
is some
one,
kind of an ambiguity.
that we withdraw, with liberty to raise whatever your contention there.
Yes, sir.
After arguing the case for some time, learn counsel for the appellant seeks and permitted to withdraw this appeal with liberty to raise all the contentions before the tribunal,
Please, my lords, National.
before the tribunal at an appropriate stage.
I'm so brief.
This is a larger policy decision on behalf of the state of Himachal Pradesh to decongest Shimla. So, my lords, in this case, we have a much larger premises available in a ready building in Dharamshala. There are a large number of other offices also in case of other commissions and boards which are being shifted. My lords, from the demographic aspect, people find it very difficult because the largest concentration of the backward communities are in the Kangra district. That is also admitted by the commissioners, in the employees representation. And there are a handful of employees, they are not going to be moved. The class 4 employees and the lady employees, my instructions are they are not going to be moved. This particular office in Shimla is going to continue functioning as a camp office where some hearings will be held. But, my lord, there can't be a blanket stay.
Your Lordship, with regard to the fact, my lords,
The High Court will decide where publicity commission should be there, where backward class commission should be there.
Your Lordship, my humble submission is that basically they have not.
Anything you shift from just Shimla to Dharamshala, we understand that when the tribunal was shifted, this state administrative tribunal, you people will go on strike. Why not continue in Shimla? Everything continue. Shimla, there is space crunch. Dharamshala is an alternate place. The assembly also takes place. Your summer, your winter session also takes place in Dharamshala. So, what is the problem if some of the offices are shifted?
It's not about some of the offices, my lords. They have also shifted some another offices. With regard to that, with regard to those offices, the Honorable High Court has not issued an order of stay, my lords. In these two matters, my lords, the Honorable High Court has taken a specific.
Was this petition filed at the instance of this landlord whose premises has been taken on rent for 22 lakh something?
No, my lords, because
Then who is the person behind it?
Your Lordship, he is the ex-member of this as feedback.
What is their problem? They are ex-member. They are not supposed to go there.
My lords, they have not even filed
And who are they to dictate an elected government that where should the office be? It is their prerogative. If you have any problem when the next election takes place, oppose them on the ground. How this issue becomes justiciable?
With regard to the decongestion, my lords, there are only 11 employees, and out of 11 employees, 6 are class 4 employees, my lords. And the building has been leased out, my lords. And there is.
Building has been leased out. When they will shift, they will vacate the building.
My lords,
Or they will utilize the building. There is a lot of other offices which require building.
on one hand, they are sealing
Why
the.
the High Court is unnecessarily indulging in these things?
Your Lordship, because basically why this relocation order has been passed on 3rd December. My lords, in December, the new chairman was appointed. Subsequently, on 24th December, he floats this proposal for relocation. So this particular relocation order, it is on the behest and for the facilitation of the chairman, my lords. It is this commission is working since 1998, my lords, over there.
Are you aware of you are practicing there?
Yes, my lords.
You know very well.
Yes, my lords.
This central, your state administrative tribunal has been in Dharamshala. Has been in Dharamshala for all the times. as and when the state administrative tribunal is constituted, it is in Dharamshala only. अरे भाई आपको पता है मेरे को पता है I was the chief justice when I abolished it.
It was circuit bench.
And since then the tribunal has not been constituted.
Circuit bench used to.
Lawyers in Dharamshala have been agitating it. I went there when Palampur court was inaugurated. The lawyers were raising all the demands. Sir, we have been having at least the tribunal, you are not constituting the tribunal. I said, no, as a matter of policy, I don't want a tribunal because a litigant has to go to two platforms. First he will go to tribunal, then to high court. So why burden the consumer of justice for that? So they agreed, they didn't go on strike, they were happily, they had some reservations, but agitation, but they never go on strike. So today if some of the offices like winter session of the assembly is being shifted to Dharamshala, what is the problem? It is not in court that lawyers will oppose.
Your Lordship,
It is an administrative office of a commission, a backward class commission. The commission will operate, they will have to make assessment in the state. They can do it while sitting in Dharamshala, they can visit other areas also. And Dharamshala is not something in Kinnaur district or where you can say accessibility is poor.
that is why.
Dharamshala has better accessibility.
That is why, my lords, the Honorable High Court has cautioned the state that the offices which are having a larger strength, they should be shifted rather than the minuscule, the offices with minuscule strength.
I should refrain itself. We are not experts on these things.
My lords, basically this.
High Court, we understand. Near the High Court, there is a government building. You suppose have space current. High Court say this building is lying unutilized or underutilized. Please give it to. We require it. High Court requires for expansion of the courtrooms, expansion of the establishment or anything. Understandable that you raise your demand. How are you concerned how the backward class commission will work?
But if it is for the benefit of only one individual, my lord, it is only for the chairman. Chairman gets appointed on 3rd December.
That is not, yes, why not? If the chairman wants to as per his convenience, let it be. People will answer it in the election.
In the meanwhile, he has also communicated that a camp office will be started at the same premises. On one hand, they are assailing this order. On the other hand, they are communicating that
Is required in the original office, but because the demographic, malad, overwhelming, the backward classes are from that area in malad Kangra. So they will find the access malad much better in Dharamshala.
But you know very well, it's not so easy to it's not so easy to travel in the remote areas in Himachal. Some of the villages still you can't go in a car. You can't go in a bus. You have to climb down. Then only you can reach there. So for the purpose of accessibility, but when we talk of access to justice, when we talk of court at the doorstep, when we talk of ease of justice, are we not these factors taken into account?
But my lords,
people who are actually backward class, don't they have a right that somebody will come to them, find out, yes, they are living in these conditions, therefore they are entitled to certain benefits of the social welfare schemes.
but with regard to that fact, my lord, from Shimla, they are doing certain other exercises with regard to the elections also.
All right. Anything else?
My lords, they have issued one communication wherein they are saying that the proposed office which they have earlier allotted for the purpose of this backward commission, now they are saying in this communication that it will be for the camp office. So once they are opening a camp office over there, my lords, so there is no point of shifting the head.
Let them decide. It is their prerogative. They want to have camp office, they want to have principal office, but they want to have any other office.
We will file the response.
Let us, the judiciary, we should remain aloof, away from the decisions, assuming those have been taken for political considerations, unless we find firmly that yes, such a decision is directly in the teeth of the constitutionality, constitutional philosophy, some part 3 or any other provision of the constitution. There we need to interfere whether it is a political decision or non-political.
My lord, they have not even filed the reply for the Honorable High Court to take into consideration those things, my lord.
Yes.
Without even availing the elementary opportunity.
And therefore, without even taking the reply, the stay has been granted.
My lord, with regard to the communications, for the reason because as per the communication, the chairman has issued a proposal. Now he is saying, and already the state is saying they are in a financial deficit, my lords. So once on one hand they are saying that we are having a financial distress, on the other hand they are shifting the offices.
There is no further explanation.
State of Himachal Pradesh is every tribe an interlocutory order dated 9th January 2026, passed by the division bench of the Himachal Pradesh High Court, whereby shifting of the office of Himachal Pradesh State Commission for Backward Classes from Shimla to Dharamsala, from Shimla in bracket Kasunti to Dharamsala has been stayed. Next paragraph. Since the issue that arises for consideration pertains to grant of adjudicate stay, it is not necessary for us to state the facts in extenso. Suffice to mention that the Himachal Pradesh State Commission for Backward Classes has been constituted for identifying the caste and communities who are entitled, who would be entitled to certain benefits meant for the backward classes. The chairperson of the commission was appointed on 3rd December 2025, followed by induction of members on 23rd December 25. The state government thereafter took a policy decision to shift the office of the commission from Shimla to Dharamshala in Vaikat district, Kangra, and to maintain a camp office in Shimla. Next paragraph. Learned counsel for the appellant state submits that such a decision was taken in public interest, keeping in view the demographic realities, as most of the backward classes, as the OBC population is largely residing in the lower hill districts, broadly known as Kangra and adjoining area. The shifting of commission to Dharamsala will facilitate the access to the commission, will facilitate the commission to have access to the OBC communities, most of whom live in remote rural areas. Next paragraph. In our considered opinion, in our prima facie it seems to us that shifting of the headquarters of an institute is essentially a policy matter where there is least scope of justiciability, save and except when such shifting directly affects the constitutional or civil rights of the public at large. It is difficult to formulate such an opinion at the stage when the state government has not even filed its counter affidavit. As the matter is pending for the High Court, we do not deem it appropriate to make further observations touching the merits of the case. However, there seems to be no justification at this stage to restrain the state from shifting the office of the State Commission for Backward Classes from Shimla in bracket Kasulti to any place in Kannada district, including Dhamsala. For the reasons above stated, we allow this appeal, semicolon, set aside the intent order dated 9/2026. The appellant state shall be at liberty to shift the office of the commission to Dharamshala or any other suitable place, subject to final outcome of the pending proceeding. That's program. The state government or the state backward class commission may file their replies to counter affidavits within a period of 4 weeks. The writ petitions may file their rejoinder if any within 2 weeks thereafter to enable the High Court to decide the case on merits. To enable the High Court to decide the matter on merits, to finally decide the matter on merits. That's all. It is clarified that the observations made herein above are for the purposes of interim stay. So the appeal stands allowed in the above forms.
We may be permitted to give a physical appearance in this matter. We may be permitted to give physical.
You want to file appearance? Sure.
Obliged.
Because item 7, this controversy can be traced back to a minor ammonia leak that happens in a French fry factory. As soon as the incident takes place, when the incident took place, my lessee was in fact in possession of the property. Thereafter, soon after, the authorities come and shut down the entire plant. I approached the High Court for desealing of the premises.
Why didn't you go to NGT? Why didn't you go to NGT?
I was impleaded.
NGT proceedings were there, you got yourself impleaded. Now you open a second parallel proceeding before the High Court.
No, if I may just correct, if I may just point out this alone. NGT proceedings were so moto initiated and I was only impleaded, subsequent.
Yourself, so if you had any grievance with regard to the sealing or its import, you ought to have approached the NGT. Skirting the NGT, going to the High Court, isn't it forum shopping?
Today I only want one small relief from your lordship's throat. I only want my right before the NGT be kept alive.
So you want to go, please.
I'll go before the NGT. Lordship may kindly clarify that they may not be influenced with the High Court's order.
You don't require any clarification. You are not here before us to seek this clarification. We are not your advisor.
The limited submission, is that the desealing of the premises can be subject to the orders of the NGT. Tomorrow, if the NGT actually states that the premises is, all the activities are being carried on in accordance with law, I have no intention of running the unit unless and until I have the blessings of the NGT.
Sorry.
I don't want to run the unit. I only want your lordships to say that the NGT may not be influenced with the High Court's order. I'm obliged.
The problem will multiply when the other party comes.
Tomorrow if the NGT doesn't find fault with me, I'll have to file another writ petition, Manoj, and get a clarification from your lordships once again.
Maybe
Is my
the
only-
life on that we have already, this is a seal of approval of this order.
I'll leave it to your lordships. I'm obliged.
Rani Sahu message, Rani Sahu.
Yes, madam.
These are which matters? These are left out matters.
Yes, my lord. Some matters which remained on that last date, my lords, when my lords were pleased to grant us the absolute bail where my lords have granted interim. These are ED bail in the same matter, my lord, in DMF, wherein the predicate my lords have granted us bail. My lord, the second one is a ground of arrest that we have challenged for Ranu Sahu, and third is a DM case, my lord, in which my lords were pleased on the first day to grant us interim protection because I was already in custody for around period of 2 years.
Are these matters where you came late and we had issued notice on that day?
No.
These are matters that were left over, my lords, which could not be heard.
Could cannot be taken. So I think we will not be able to take a different view.
In item 9 minutes is a writ petition. 8 minutes.
Malad, I appear for ED in 8 and 8.5, Malad. Sorry, 8 and 8.1, Malad.
So do you have that old chart which we are having on the, Madam Ashwarya, do you have?
In my matters, Malad, for ED, your lordships may record my objection and I leave it to my lord.
All right, yours is item
8.1, Malad.
8.1.
Yes. 8.1 is arrest, Malad. I think there may not be too serious in pressing that. That's quashing of arrest.
My lord, 8.1 is we were challenging the ground of arrest. So my lord, if bail is being granted in 8, my lord, then we will not press that.
Yes, so lordship may record that and then I.
My lords, I appear.
Because of 8 and 8.1.
Also do.
In this matter, Malad, interim bail was granted on 29 May 2025.
Where do you know?
Is going to be another.
And is also this Ranu Sahu,
So 8 and 8.1 are Ranu Sahu, Malad.
the ED matter.
Yes, 8.1 they won't press. They are.
इसके खिलाफ में है और
So lordship may record that. An interim bail, Malad, was granted on 29th May 2025.
Lords, 8.3 is also a bail matter of a smaller player.
8.2.
come one by one. So this 3145.
My lords, that is the ED DMF bail, my lord, on which my learned by the senior is saying that she is not going to press only formal objection and the interim bail of 29.5 can be made absolute. 8.1 I will not press, my lord.
Anyway, 3145 we will allow
My lord.
in the sense that interim bail already granted is made absolute. Huh? So this will be same order as
Yes, my lord. Same orders.
where we had earlier recorded Mr. Raju had appeared on that occasion. So same paragraph except that instead of Mr. Raju, Madam Ashwarya will appear. So 3145 is allowed to this extent.
3644 not pressed.
And which one you don't press?
My lord, 3644, my lord, it was in the same matter, ground of arrest we had challenged in the High Court, my lord. Say SLP against that, my lord.
No, 3644.
Yes, my lords.
You don't
We will not press, my lord, because my lords have granted us bail, my lords.
say in the fact that while separate order of even date the petitioner has been released on bail,
My lords.
Commander and Counsel for the petitioner does not press this petition.
Most of
So accordingly dismiss is not pressed for. So now we are left with at serial number 8 there are two matters only.
No, my lords, there are more.
No, it's 8.2 is a writ petition filed by Ranu Sahu Mills. No notice has been issued, we have not been served Mills 8.2.
8.2 is a writ petition, my lord, because I was arrested 3 times consecutively. Whenever my lords used to give us,
We can't issue omnibus direction, it will be very difficult. Tomorrow if you come assuming, we are not saying about you, but assuming a person, he says grant me a a preemptory bail order and he commits murder, the authority will be helpless. They will keep on watching there because the Supreme Court has said that no, we can't arrest you. It all depends upon, we have been rescuing you as and when occasion arises.
My lord, I bow down to that. We only came, my lord, after 2 years, when my lord on 3/3/2025, in a matter where I was under arrest for around 1 year, 8 months, my lord granted us bail. ED on the same day moved the production, my lord, and then sought my arrest. It is only then, my lords, there, because it was becoming something in perpetuity, my lord, because I was getting bail by my lords were kind enough to grant us bail. The next day or the same day, either EOW or ED was coming and arresting us, my
But it
lord.
seems from the variety of cases against you by ED, by Anti-Corruption Bureau, by this,
My lords have been extremely kind to us, my lords.
I think my
Same property.
choose between not pressing or dismissal.
No, no, my lords, it's writ, my lord. The same issue, same properties is being circulated in all cases, my lord. In DMF.
maybe obviously because you have, their allegation ultimately is what?
Statement.
That you being an IAS officer, you misuse your position, abused your power and earned illicit, right, benefits, maybe through gratification, maybe through shareholding, maybe whatever. These are all set of allegations subject to trial. And you have parked that money in buying some property in your name, buying property in the name of your brother or your family members. So ultimately it is the Indian currency only. They are not talking that you convert it into dollars. It's the same property, same set of allegations.
I am in my lord's hands in this, my lord. My lords may decide it as these are issues that we have raised, my lord. One only thing, my lord, that there were DMs after me, there were DMs before me. Nobody has been investigated also, my lord.
Withdraw this petition saying that you will approach the appropriate forum as and when occasion arises.
Permit us to come back also, my lords, if they file another case.
You have been, there is no question of coming back. You have never gone out of the court. You have always been here in one or the other matter. You are always, any litigant who is aggrieved by of an action or whose liberty has been supposed compromised, we never say our doors are closed. You are always,
I leave it to my
we'll
lord.
consider as per law. Then after arguing the case for some time, learn counsel for the petitioner does not press this petition. As according to him, he will approach the appropriate forum as and when occasion arises.
My lord.
Further recordings.
My lord,
Now, any other item?
8.3, my lord. 8.4. 8.4.
8.4.
8.4 is a matter where anticipatory bail
Yes, approve.
of Ranu Saumalas. My lords were pleased to grant an interim bail on 29/5.
that
And in the matter.
Yes, my lords, in DA case.
So here also you make the same,
My lord.
we have also made absolute on the same question.
I'm most of that.
My lord, 8.3 also is the same. It's a Manoj Kumar Dwivedi. He's a smaller player.
Yeah, my
He may also be granted.
8.3 is.
8.3
Manoj
that's
Kumar
it.
Dwivedi.
Yes, my lord. Manoj Kumar
So
Dwivedi.
that's also same.
He was granted.
I'm 8.3, I don't know.
8.3 is an ED matter,
ED matter.
Lordship. Mr. S.V. Raju appears.
It is that, you are right. It is.
Yes. In that matter, he had asked me to take a
He
passport.
is not better than,
I get it. The interim order is there already.
the same order, follow. ये ईडी का मैटर होगा, इसमें मैडम ऐश्वर्या का इनका साथ में सी ओपीडी इंडिपेंडेंट राजू साहब
Yes, yes, Mr. Raju.
Raju along with this
Yes.
young man. 8.5 is also
Well,
there.
8.5, he was not arrested during investigation. He's an excise officer. And my lords have granted bail.
Excise officers all and.
My lords, while order dated 29/8/2025. Well, he was not arrested during investigation and was granted bail by this court, interim bail. Yes, well, interim bail.
Release now.
Yes, well.
Say the
Same. I need to verify them.
no, this is Bedram Lare, na?
Laren.
So we had passed an order on 23rd September 25. Meanwhile, make it absent. So we made,
Yeah, absolutely.
so for the reasons recorded in our order dated so and so, passed on so and so day, the interim order dated 23rd September 25 is made absolute. And the same permanent commissions which we have imposed in the similarly, in the case of similarly placed cases, quite. All right, that is also finished. Any other matter?
Well, item 9.
Item 9.
9, my lords, I'm seeking 2 weeks' time to file a rejoinder. Their counter has come in only on Friday.
Malas, this is the
2 weeks
same
after that.
matter as
My lord,
Ranu Sahu.
hold on, my lords, they filed a counter affidavit. Will come back.
This same, he's seeking similar omnibus prayer, Malas.
I want to file my rejoinder, my lords. I don't know why should there be a problem with that.
Similar matter as
Notice, my lords.
prayers are similar to that as.
Come back in my this thing, my lords. They filed a counter on Friday.
You can approach the appropriate.
My lords, I have already approached the appropriate forum. I've come not in a direct 32 here. I've come against a 226 dismissal. So please give me 2 weeks, my lords. I'll come back in my rejoinder also. There are some new facts that they've taken. We'll respond back. After 2 weeks, if your lordships will have.
No, the impugned order is declining bail or,
My lords, my
application
application
that.
is rejecting alternative remedy one, and then second saying that you should have either filed a quashing or you should have filed a anticipatory bail. Now, neither of them in my case will apply, my lords, and I'll point out why. I'm just taking 2 weeks' time, my lords. If your lordships will accommodate me only for 2 weeks.
So it will take up from Sunday. What about 10?
My lords, in item 10, I am seeking a pass over, my lord. Item 10, I am seeking pass over.
Small player. Warrior. He can also be granted. He is there for the ED.
ED Lordship, I am appearing, I am led by Mr. Raju.
So he is a very small player as compared to.
Yes, but Lordship, if sees the prayer B does not exist because prayer B was not there in the special court's order. So prayer B does, because Lordship, the order that was granted bail said the conditions will be imposed by the special court. Special court has not imposed any condition that is pleaded in prayer B of the IA. So prayer A, I leave it to your Lordship if Lordship wishes, but prayer B does not.
Conditions to be imposed, sir.
That very stringent conditions we impose.
Yes, but Lordship, I am saying.
Condition will apply here also.
Yes, but Lordship, if currently comes to page 5, prayer B says, direct the petitioner to report to the concerned police station, EOW, ACB, Raipur or any other police station once a month or fortnight. That condition was not imposed by the special court. So the condition that she is asking for waiver of is not in existence. That's what I am pointing out.
So what is prayer number 5?
Prayer, page 5, Lordship comes to the IA for modification of bail condition.
Prayer B. What is it?
There is an IA.
To the concerned police station.
Yes, this condition was never imposed by the special court.
This was never imposed, so this is infructuous. No, sir.
Yes. Lordship will find the conditions that were imposed in page 13.
My lords,
Yeah, but where is this condition imposed by us in the order of 6th of October?
Yes, Supreme Court by order dated 6th of October said conditions will be imposed by the trial court. Lordship will see that in page 9 of the same IA. The Lordship will see the conditions which were actually imposed by the special court in page 13.
Yeah, but 6th of October is very short order by us.
13, 14 years of conditions imposed.
These are conditions imposed by the trial court.
Trial,
Yes.
there is no condition of meeting the investigating officer.
Reporting. Which is the condition this one?
Stay outside, stay away, submit affidavit, surrender his passport, and so on, so on.
Yes.
my lords, eyes.
Mechanically it has come.
For the enforcement, pleading Shri Raju along with so and so on behalf of the enforcement directorate, format informing order dated 6th October 2025 is made absolute, subject to the same terms and conditions as have been imposed by the special court, special judge.
Special Judge Dhan Sadan
Which place?
Sixth Additional Session Judge, Raipur, Chhattisgarh.
Special Judge in bracket Money Laundry Act, Sixth Additional Session Judge, Raipur. Wide order dated so-and-so.
7/10/2025.
70.
Order dated so-and-so.
7/10/25.
Grateful, Lords. Please.
Now your matters are over, which Chhattisgarh.
One item is there. Please, Lordship.
14
is still left.
14. Okay, we'll see, just in 2 minutes we are reaching the 5 minutes. Item 11.
11, I must at the outset apologize. My counter was filed a little late, but I have copies, my lord. I filed a counter for the state.
In item 11.
11.
Counsel for the state of Maharashtra state flat. Counter affidavit has been filed. The same is not attached to the, is not tied with the paper book. Registered to do the needful. Next Monday. Next Monday.
Next what I'm.
Post the matter next Monday.
I am grateful, my lord.
My lord, one request, my lord, if possible, may be kept on 18th. Monday 16th. 18th is if possible.
All right, sir, we will comply with your direction. 18.
I'm grateful, obliged.
Yes.
I think 12 minutes.
Item 12.
12 minutes. Charge sheet was laid, my lord, in the year 2023. I appeared before the court, coming up after notice, my lord, I appeared before the court, executed the bond. Subsequently, on an application filed by defect complaint, one more charge was added. Therefore, my lord, my bail bond was cancelled. I moved for anticipatory bail. Sessions Court granted anticipatory bail. The Honorable High Court reversed it. So against which I am there, 2023 minutes. Violation of trademark.
Your anticipatory bail was cancelled. We have stayed that order.
Yes, ma'am.
Wants to make it absolute.
Granted.
My lord, they have not only misused my company's name, they've been selling poison to the public. High Court in its order, my lord, High Court has clearly said, where is that order? That is page number 198 of their SLP, my lord. High Court says that when they went for testing, they were absolutely unsafe for human consumption. My lord,
That's right, that for that, whatever the trial will take place, and if they are found guilty, obviously they will face the.
I say, my lord, the bail was granted only on the ground that overlooking section 467. They said all the offences are, I apologize.
The best course for the state is that, the powers are very well there. They can seal the premises, they can close the premises where it is found that what is being manufactured is basically a poisonous substance. They can always do that. There are other provisions. That does not mean that criminal case will not continue. Criminal case will also continue. But for that preventive measure, they can take other steps.
My lord, High Court has said that you surrender and apply for regular bail.
State, and we hope that the state will.
Madam, I'm very for a state, madam. My only the legal submission is that once they have appeared and took regular bail, then the question of anticipatory bail is not there. They should go and take the regular bail. Who is going to
Bond was
stop?
cancelled. Therefore, we.
We have had lunch here, counsel for the parties. Party. It seems to us that there do not exist sufficient and valid grounds on the basis of which the High Court could recall the order granting anticipatory bail to the petitioner. Consequently, the appeal is allowed. The impugned order dated 17 December 25 is set aside. It is directed that the appellant shall continue on bail subject to same terms and conditions as already imposed during the pendency of the trial. Next paragraph. It is however clarified that the granting of anticipatory bail shall not be an impediment for the competent authority to take other preventive measures against the industrial unit if it is found that the product contains any poisonous or unhealthy substance. We have clarified that, now we can.
No problem. Like,
Safety law को करना, food safety law में करना,
Under the
FSSAI.
describe the total.
we come from that sector. Next year, producing, that's why I got that. Okay. Yes, Manoj. Yes, yes, my lords. Yes, despite this vicarious liability, my lords, so just explain that. I've already undergone 9 months, my lords. If it is considered the section 26, that is violation of conditions of license, the maximum punishment.
Show the person from the respondent.
Don't argue that, sir. Don't argue all that drug and cosmetics.
Please, my lords, I'll argue on merits.
Back to your point, this
Kind of medicine your partner is recommending, it is not under the drug and cosmetic.
Yes, ma'am.
Very easy to see.
No, I'm talking about 26 only. But NDP is 26. But on that, my lords, I'm not leaving that for the moment. On merits, my lords.
No, if Dr. Malhotra had requested.
Yes, he is true, my lords. And he was running. I'm only a silent partner.
But we are surprised doctors are doing.
But Lord Sirashma, kindly see, there was no animus because in fact they are searched.
In Punjab,
It's a malice. It has to be.
drug mafia includes.
Yes, it's a mafia.
People are making lucrative money, the doctors, the so-called industrialists, the police, and so many people are hand in gloves, unfortunately.
But one interesting thing, my lords, why this Malhotra might have done it, because the search in the pharmacy took place on 28th. Then thereafter, the search here took place on 2nd, next month. So even knowing that the search took place in the pharmacy, these people thought that this is nothing illegal here. Otherwise, they would have removed it. If they had some idea, Malhotra on paper, no person with a reasonable sense will not order something.
Let us not open our mouth because it's for the prosecutor to move the case.
Absolutely.
But this was under the cover of using it as a medication. They were dealing with a schedule H drug for which even the hospital does not have the license.
Officer not going to.
Deeply obliged. Return of some early date may be given.
Trustee also.
Deeply obliged.
Notice देना है people देखो.
फर्दर वाला है सर
Yeah.
14 है ना
I'm the petitioner.
Article item 14. But not like one endpoint, but for the state.
I'm there in one.
Password? No, not a password, not a.
14 there is a cancellation. ये वो दूसरे वाला है सर ना 14 वाला पेल से देना सर उसके अंदर सिंगल ग्राउंड्स पे बेल मिली है सर डिटेल में ऑर्डर है सर वो कहते हैं कि इशू कर दो उसमें सेक्शन ये बोलेंगे ना उसमें स्टेट ऑफ छत्तीसगढ़
Take up this matter after some days.
At least notice may be issued.
No, my lord, I have serious objections to this. This was argued at great length. Your lordship will see the orders. Every contention has been considered.
Well, there, that's my whole case. I'll point out in two.
No, I'll also point out.
Notice again delay, my lord. At least
No.
it should be issued. I'll point out that none of my arguments
My lord.
have been considered. And my lord, there are some propositions of law, with the greatest respect to learned judge, my lord, which are not tenable.
But it's a very
Your,
detailed order.
your lordship will see.
Detailed
50
order.
pages.
It's not a detailed order.
And people not a regular.
How can-
Against a bail order. It should be a ground.
It is not a detailed
So
order.
now every order will come on an appeal like this.
59 pages of narration of facts.
Coming. In every case, my lord, this is.
Every aspect was considered, my lord, and at length for many days.
I thought it's my petition, my lord. I should be.
We are opposing your petition.
Of course.
By saying this is the attitude of.
Yes, yes, but I am.
The
We'll show your
first
attitude.
case, my lord. The lordship has done, my lord, so many of these cases.
Today, for some reason, we are not saying anything for today for some reason.
Very well.
We'll take up this matter after a week or so.
1-2.
Yes.
After 2 weeks, my lord, I have some difficulty. My lord. After 2 weeks.
My lord, because this man has been released on bail, a vital witness is not attending anymore.
My lord, that
Best,
in fact
his
is an
best
issue
friend
which
Manav,
needs to be.
chap called Manav Saxena. Well, I'll point out what kind of.
You can bring those, so if any subsequent events.
Yes.
Because 2nd January is now more than 1 month.
Yes, we will be
If
there.
there are any visible subsequent events, you can place on report. Meanwhile.
One of the main grounds of vitiates it is, my lord, that this man's name was not mentioned in the FIR, therefore it should be granted.
Lord, may I draw your lordship's attention, my lord Chief Justice. My lord, in 14.2, this is that lady Soumya Chaurasia. Soumya Chaurasia. My lord, she has been granted interim bail in a large number of cases by your lordship. My lord. She has spent 2.5 years in jail in and out. Your lordship asked her to stay out of the state. Now they have registered a fresh FIR in December this year, again relying upon material blood of 2019, and she is arrested. I am requesting. But December is much before we pass this order, last order.
fresh FIR.
December means much before. No, I am. My lord, arrest is in December. She has been arrested now in December. My lord, I am praying for interim bail. My lord, she has been granted interim bail by lordship for the last 2 years. But filed some petition, Mr. We have filed. It is listed 14.2, my lord. Notice was issued by lordship.
14.2 and 14.3, Mr. S.V. Raju appears as taking a passover.
In the liquor case. This is ED liquor.
14.1 and 14.2.
No, one is unrelated.
This is the 6th time she is arrested. 5 times I have got. 14.2 is a writ petition under 32. Yes. I am saying this is not a evergreening of arrest. How many times, my lord? 22, 24, 25. 6 times the lordship granted her bail. My lord. Pick up your matter within a week. You file a petition there. The instant writ petition under Article 32 has been filed. Lordships have granted by the petitioner
Notice issue.
pursuing the vagaries of section 44 of the MLA. However, we find that in substance, the petitioner is seeking her release on bail in a matter in which she has been arrested. And what is the date of arrest? 16 December 25. In relation to the liquor scam, has been arrested by Directorate of Enforcement in relation to liquor scam. Since the primary relief sought by the petitioner pertains to grant of bail, we relegate her to approach the High Court of Chhattisgarh. It may be Chhattisgarh. The petitioner, from my issue advice, may file a petition. Petition within 1 week. Yes, immediately. In 1 week, the High Court is requested to take up the matter on out of turn basis, on priority basis, and make an endeavor to decide to decide at the earliest, but not later than 2 weeks.
Very good.
But not later than-
Very grateful.
The High Court will also keep in mind the various orders passed by this court granting bail to the petitioner and other co-accused. This order.
14 and 14.1.
Lord, she has also been arrested by EOW now. So, Lord, your lordship's Lord, observation may apply, Lord, there also.
She has been arrested by now, by EOW.
Lord, this was ED, what your lordships have dictated.
Instead of ED, then
This was ED. Now, Lord, after that, she has been arrested, Lord, by EOW on 2nd of January 26.
we think that the petitioner has been further arrested in another case by EOW.
Chhattisgarh.
Economic,
Offences wing.
so and so. Then the petition may apply in both the matters.
Correct.
Then
Grateful. And very good.
So my lord is placing 14 and 14.1 together on a separate date?
There's no connection, Lord, please.
No, there's no correction, I agree. 14.1 was in relation to the evergreening of complaints, my lord, again and again. Without seeking permission of the court, there was a point of law in that your lordship had.
This is the first time I've heard of accused who themselves evergreen, now accusing the state of evergreen.
That is ED.
Yes.
That's ED, sir. You're not in that.
No, but therefore.
Evergreen. 40 and 41, we can take together.
Can it be after 2 weeks, bro?
After 2 weeks or 10 days, give a day.
So grateful.
Both matters are 14 as well?
Both.
14 and 14.1 is filed by you.
Yes, bro.
That is ED matter.
That is the ED matter.
That is not your case, Mr.
That's
Jatnai.
14.1, but your lordship may keep them on separate dates.
No, 14 and 14.1, don't tag them.
Don't tag, that's
14.
that's my
That's 14 or 15 like this.
Yes.
And be tagged and listed separately, but on the same day.
So grateful.
Obliged. Grateful, Lord.
Please, my lord. Lord, pursuant to your lordship's order, my lord, of 27th of January, there is a fact-finding report, my lord, that the loss caused is only 3 lakh of rupees. And what the penalty sought to be imposed, my lord, is 12 lakhs, my lord. We leave it to your lordship's, my lord.
This item 15, are you referring to?
You kindly have your lordship's order, my lord, of 27th of January 26, my lord. Last order. Issue notice, meanwhile, interim anticipatory bail is extended. However, Chief Secretary are directed to submit a tentative fact-finding report with respect to the loss caused to the state revenue, including in terms of the value of the illicit transported minerals, which is attributed to the petitioner. It is made clear the continuation of the bail will depend upon it.
Well, is there any report filed?
Lord, yes, Lord, we filed that report, Lord. If your lordship has the fact-finding report, he, in this span of 2 months, Lord, he extracted about 4,314 tons of illegally mined this thing, minerals. And the total penalty which the state is to recover from him is about 12 lakhs.
According to you, the loss is 12 lakh.
12 lakhs, yes.
7,000.
This is the penalty, Lord, but this is apart from the
Loss is
fact.
3 lakhs. Loss is 3 lakhs, my penalty is 4 times, my lord, the loss. That your lordship will
You
get.
can afford to deposit without prejudice to your rights.
Lord, this is only
Lord,
small.
this man is a habitual offender.
Transporter, my lord,
There is sometimes a presumption. The presumption is that the litigant who can afford to engage Mr. Devdutt Kamath
My lord, I'm sorry.
seems to be having capacity enough to deposit this fine amount.
Lord, he's
Lord,
a
the loss-
repeat offender, Lord. Earlier also, a penalty of 90 lakhs was imposed on him, Lord. Not only that, he was absconding. We had to issue proclamation notices.
Nobody
He's a flight risk as well, Lord. So I was only wondering, Lord, whether we lordship would ask him to, now that the charge sheet has been filed, and the charge sheet discloses, Lord, the charge sheet now discloses that he used fake E-Ravana papers, Lord, to transport.
Lord, I have lot to say on the charge sheet. After give me a.
No, charge sheet has been filed.
Charge sheet
Yes,
has
my
been
lord, charge
filed.
sheet is filed.
The petitioner was denied pre-arrest bail, anticipatory bail by the High Court of Uttarakhand. By the impugned order dated, leave granted. The appellant was denied anticipatory bail by the HighUrt of.
No, he was granted anticipatory bail, but only
Only for 2
he was
weeks.
granted anticipatory bail,
It was
but only for
dated.
15 days, so that he could seek regular bail. That was the bail. That's the
That is
order.
completely contrary to lordship judgment.
The, say like this, the High Court of Uttarakhand, by the impugned order dated 30th December 2025, granted anticipatory bail to the appellant in case number so and so, so and so. However, limited the operation of that protection to the extent that limited the operation of that protection for a period of 15 days, meanwhile granting liberty to the appellant to approach the jurisdictional court for grant of regular bail. The aggrieved appellant has approached this court. Then say on 27th January 2026, the following admissions. Then say in reference thereto, a fact-finding report has been submitted by the authorities, according to which the appellant is alleged to have caused total revenue loss of rupees 12,07,927 only.
Plus 3 lakhs is the loss, penalty they say it comes to 12 lakhs, my lord. Loss is only 3 lakhs.
So, has caused loss of 3 lakh to the revenue.
No, that is not
along
our.
with the penalty of this 12 lakhs only.
Page 6, my lord, of the.
Next paragraph.
No, it's not significant.
It is not understood that investigation is complete and charge sheet has been filed. So that being so, from our view of the view that the appellant can be allowed to continue on pre-arrest bail, subject to however is depositing the amount tentatively levied. The amount tentatively levied of the fine and penalty, subject to his deposit of the levied amount of fine and penalty. The appellant will deposit the requisite amount within 2 weeks, without prejudice to the rights of the parties.
Yes, ma'am.
Next paragraph. The appellant shall be at liberty to challenge the levy of penalty or the levy of fine or the penalty before an appropriate form in accordance with law. Next paragraph. Similarly, the deposit of fine or penalty shall not absolve or exonerate the appellant from the penal consequences, if any, and so all those issues shall be, if any, should be, and thus the trial court will proceed against in accordance with law. The trial court shall proceed in accordance with the law.
Lord, the conditions imposed by the High Court will continue, Lord. So, Your Lordship may, the conditions imposed by the High Court for grant of bail, those will stand incorporated by Your Lordship's order as well, Lord.
The appeal is allowed for one plain order of the High Court is satisfied.
Lord, the only request is whatever your lordships have said,
Is allowed in the border.
whatever your lordships have said, my lord. But my lordships may say that not affect the merits of the case, my lord, because ultimately
Those you have clarified that we have not expressed any opinion on merits of the case.
extremely grateful.
I'm grateful.
Item 16.
May it please, please. You have said, directed me to inquire about the antecedent of this, the petition. Well, there are none.
No antecedent.
That was the only.
No antecedent. He got money in respect to online fraud, but
The appellant is aggrieved by order dated 11/12/25 passed by the High Court of Chhattisgarh at Bilaspur, declining in bail in FIR number 157/2025, registered at Police Station Raipur under section 111, 317 in bracket 2 and 317 in bracket 4, 317 in bracket 5 of BNS 2023. The appellant was arrested on 6/10/2025. The allegations are that during the period 26 June 2025 to 6 July 2025, The appellant's two accused, Indra Vishal Bekra, operated multiple bank accounts through which online fraudulent transactions aggregating approximately rupees 9.45 lakhs were received. The appellant is alleged to have assisted the above named accused by providing a mule account, and he received a share of the proceeds in cash. As per the having regard to the nature of allegations and the period spent by the appellant in custody, or without expressing any opinion on merits, the instant appeal is allowed. The influence of the High Court is satisfied, and the appellant is directed to be released on bail. Subject to his finishing bail bond to set at the trial court. He is to back the bail appeal. You are still unhappy?
No, my lords, I'm in custody, my lords.
No, if suppose you like the jail premises or the jail atmosphere environment, then we can dismiss the petition. We can allow you to stay in jail if you want. Otherwise, we have by mistake granted bail to you. You want to go on bail or you don't want? And then you should go by with a smiling face from court. Why you are so showing as if you are under depression? Thank you, young lady. Thank you. Item 18.
My lord, item 17, my lord.
Just
17 minutes.
My lord, 17, my lord. I am praying for bail, my lord.
70? Fine, I think. Or 70 also?
Yes, my lord.
You are the main accused. This main accused.
The main accused, my lord.
My lord, I am.
इसको बेल दे दो
मतलब
अभी तो छोटी मोटी चोरी केस है
Same reasons, my lord.
my lord has granted me bail.
दे दी भैया बेल दे दी क्या साहब आपसे डर लगता है पहले item 18
But bail was denied to me while granting bail to others. For me, my bail was denied because I happen to be closely related to S7. So he is absconding, he applied for anticipatory dispute. That is the only reason given. Your Atma kindly come to pay 31. Long incarceration.
the main.
how much you made money as per the allegation
732 crores.
only
A7 is the shell company. Owner
Your
of
Atma
the
kindly come to pay 31 minutes.
not
But long incarceration is the only ground.
9 months only.
My lords, 10 months now.
only.
Now 10 months, almost 10 months.
For 700 crores, 9 months. Look at
That is why I do not want to go into the merits of the matter now.
look at the eminent position and the seat of power you have enjoyed. There is a direct nexus between the allegations attributed to you and the position you held for a long time.
That's I will.
And you are not an ordinary and small kind of person.
But
And after investigation, there are definite allegations against you of taking a huge amount of bribe and
I will not.
visible in your accounts or in your known sources.
But at this stage, I do not want to go into the merits of the matter. At this stage, but I will argue the matter on merits when they file their counter. No, for the present, I will submit. All the other accused, most of the accused are similarly placed to granted bail on the same ground.
We have granted bail, we are aware, but not, those were having very small fry.
No, same thing, same. Your Honor, kindly see, so far as accused number 34 is concerned, the similar or graver allegations. All. Almost, all, according to the case, all acted,
The order, page 31 of the order.
not only me. The others also similarly placed, they have been granted bail. Yes, Murad. Yes, Murad. But so far accused number 1 is concerned, closely related to determining factor, closely related to A7 who is absconding now. Another influential supervisory role, that's all. For the next man, the investigation substantially complete, no direct recovery, risk of absconding or tampering not shown, role more facilitative than controlling. Then next minutes. Investigation complete, co-accused with similar or graver allegations granted bail, prolonged detention would be pre-trial punishment. Same. The next member charge.
You are the central conspirator, first of all.
No, I,
Central conspirator,
your Honor,
orchestrated liquor policy, influenced opioid allocations, promoted blue-eyed brands,
your Honor, kindly come to.
collected
I will,
kickbacks
I
of
will.
50 to 60 crores.
Your Honor, kindly come to Murat's page, Murat, paragraph 44, page 24. Murat, the allegations against me have been, Murat, almost my similar allegation against others also. Murat, charge sheet has been laid, I have been in prison for Murat 10 months.
No,
Your Honor, kindly say.
allegation against him 732 crores.
That's right. Your Honor, kindly come to paragraph 44, Murat, of the order, page 24.
Nagamotu,
My lords.
the shell company in which 750 crore was parked, as per paragraph 45 you indicated,
Yes,
is in your direct control through A7.
No,
This is the prosecution case. Now, if you accept that, you stand clearly on a different footing to A6, A34.
I will show Murat the other accused for whom bail was granted. Murat, the graver offences than me. Murat, they are also.
Wait for some time, Mr.
Murat, for the present, Murat, my humble submission should be Murat. Murat, they can file counter. Murat, I will take your lordship, Murat, and place records also to show that absolutely, Murat, there is nothing against me, Murat, and these allegations are very minor.
At best, you can make out a case for cancellation of bail granted to some others, but that will not help you in getting bail.
Murat, Murat, that matter is pending before this honorable court. Your Honor, kindly take this along with that. Your Honor, kindly see, Murat, in respect of some other accused, Murat, bail was granted, challenged before the court, pending, your lordship was granted stay of that. High court cancelled, Murat, your lordship was granted stay. That is also pending before your lordship.
No, those were.
That matters be disposed of.
They have disposed of.
There was question of statutory bail. We said that without going into that question, they will remain on interim bail and the issue will be decided on merits.
Well, if your lordships, Murat, decide to go into the merits of the matter, Murat, I may need some time. Murat, kindly have it, Murat, this Friday. Murat, I will argue elaborately, Murat. I do not want to waste the time of this on today. Murat, kindly have it Friday. I will argue, Murat, elaborately, Murat, and demonstrate.
How does it matter, Mr. Nagmuthu?
My lord.
Monday or Friday, how does it matter? You can argue today whatever you want to argue.
Murat, today, Murat, kindly consider to
You are not inclined to engage in bail at this stage.
Murat, I
If you
got
want to argue on merits, you are welcome. We can't stop. But please, you will not invite any observations from us on merits also. Today we are only simply to say, at this stage we are not inclined. After the examination of some of the vital witnesses who have direct bearing on your accusation against you, liberty to apply afresh before the High Court.
Murat, kindly, at least your lordship kindly have it tomorrow. I will argue the matter elaborately. Your lordship kindly, for my sake, your lordship kindly have it the matter elaborately. Tomorrow, Murat, at least. Or subject to my lord's convenience any day. Any day subject to my lord's convenience. Tomorrow is inconvenience for your lordship. Your lordship kindly have it any day. I will argue the matter elaborately. Any day, I am not asking for any. Any day, Murat. Friday, this Friday, Murat. Subject to my lord.
Friday will not Friday.
Any day, Murat. Subject to my lord's convenience. Any day.
Before Friday, tell us onward. Day after Wednesday.
Tomorrow, Murat. Tomorrow, Murat.
Day after we are arguing.
Day after tomorrow, I'm not here.
On Thursday?
Thursday.
On Thursday.
Thursday. Good.
Now, Lord, this is a case, Lord, where a closure is ordered of a chemical factory. Now, this is not a case where the factory is deficient in any manner. We are functioning for 10 years. We are fully compliant. The allegation is that, Lord, we have to dispose of spent hydrochloride acid, which we use For manufacturing, my lord, an intermediary product.
There, Mr. Rodgi, deputy. Okay.
Discharging the acid in Narmada Canal.
In the Narmada Canal.
So what has happened is this, my lord. My lord, I have to use an approved vendor, which is, my lord, a transporter, approved by the Gujarat Pollution Board. I can't use any truck I like. I have been using an approved vendor, my lord, for 5 years. They have made more than 500 trips. There has never been a problem. It has to be disposed of in that man's factory, my lord. That's how the hazardous rules provide. Now, my lord, I accept what has happened. Apparently, this driver on this trip did not take, my lord, the product to the factory concerned for disposal, which has been going on. Apparently, my lord, the allegation is he disposed of in a canal, etc. Now, if that is so, my lord, there can be some penalty. The penalty can't be that you, my lord, throw the baby with the bathwater.
No, we are not saying that what
wrong has I done? I have chosen, my lord, a vendor approved by you. The driver went elsewhere.
The point is, Mr. Rodgi, that whatever mechanism you had for disposal of.
Yes.
That has been found to be faulty.
No, my lord.
It is faulty because they don't have control. Once the material, this liquid goes from your factory premises
To another factory. Yes.
You don't have any physical control on the driver because you have hired an agency. And assuming this truck is caught, we do not know how many trucks went unnoticed.
I'll answer that. It can't be because the actual live movement of a truck approved vendor under the hazard rules is on a website which is alive and
Mr. Rodgi, please see. It
is GPS enabled.
It's a question of life for millions of people.
I agree. I can show you. Show me.
Only source of drinking water in that space.
I am not saying no. I am saying, my lord, if it has happened, the remedy can't be closure.
We are not saying that. Your remedy will be that you will have to satisfy the NGT that what kind of preventive measure you will take. It will be a scheme.
Show me that. Show me that movement. Physical movement.
So page 7. Page 7.
Your lordship is perfectly right. I will show you, my lord, that there is a live GPS of every truck with this number moving, my lord, on a screen, going from A to B. When I saw it myself, there was some diversion, my lord, of that truck. That is, my lord, this is how it is done by GPS.
This you can show to the NGT also.
No, I only wanted to say, my lord, this man may be remiss. This is how, my lord, it goes. This man may be remiss. 1 out of 500 trucks may be remiss. I am not saying no. But the remedy can't be to order a closure of the factory. You may have some penalty, something. I can understand.
We are not saying at all that what should be the proportionate person.
Correct.
You are entitled to argue on the doctrine of proportionality. That you can, but you can argue it before NGT.
Proportionality, I agree, my lord. Proportionality is if I have committed something wrong. I have chosen a vendor. What else can I do?
Under the hazardous rules, Mr. Rodgi, it is, the vendor is considered to be your agent under the
approved by them.
Extended product liability.
Correct, but approved by them. What else can a man do? Some penalty, yes, but.
The Honorable Chief Justice indicated to that it is a question maybe of proportionality in the embargo or the interdict.
If I am remiss.
That is to be examined by NGT.
Once you will submit a scheme to the NGT, that yes, this mistake or lapse has happened, but to prevent it and to ensure that there is no violation in future, this is my scheme.
And this is what I am doing, my lord, for the last 10 years.
The tribunal will consider that.
Only one more request. My lord, now the order has come. That day the order wasn't there when he mentioned, my lord. The order, my lord, of the High Court has come now. Have a look at that. See the last portion. I want to make one submission there. I filed that order separately, my lord. It wasn't there.
It's impugned.
It is now impugned. Yeah.
Part of the
See page 15. Last portion, my lord.
Para 23. Yes.
Yes. Liberty rests with the petitioner to approach the pollution board for seeking
State Pollution Control.
Yes, to seek revocation or go to NGT, my lord, and these observations will not come the way, etc. Now, I only want to state, my lord, on 5th of February, I have gone to them. that, my lord, representation is pending.
We can direct them to decide. Here.
Decide only one thing, my lord. Till then, the closure, my lord, should be in abeyance. Why should I be closed?
That part.
So even if you decide in 1 week, my lord, your lordships consider a man who is not remiss on his own factory is not remiss, my lord.
You simply tell us that have you approached the state control policy?
Yes, I have approached them on 5th of February. I have placed it on record. And I wanted a stay. That's why you mentioned to my lord the Chief Justice on Friday.
No, we can simply direct the pollution control board
Yeah.
to decide that matter within a week.
After giving me an oral hearing, my lord, I will show them this.
Of course.
Number. But till then, my lord, there should be no coercive steps. My lord, what is the advantage? I produce, my lord, for anesthesia. I give it to the government. I give it to all that. There has never been, my lord, a remiss position of this factory for 10 years.
You see, sometimes the harsh actions are required to be taken to convey a very stern message to everyone.
I understand that.
You can't play with the environment like this. That is only maybe.
But my lord, to paint me black because one black sheep may have been remiss is too harsh, my lord, for a closure. I employ 500 people, my lord. I have never been remiss. There is not a single instrument, my lord, equipment which is not installed. Consider, my lord.
They can consider the main matter.
Just consider this, my lord. Every day your lordships have cases where there is affluent flowing from factories.
Good company. Operating a manufacturing unit at Dahej in Raipur, Gujarat. The spent hydrochloric acid,
Yes, spent.
in bracket spent HCl, is generated by the petitioner's industrial unit as a byproduct. According to the petitioner, that spent HCl is supplied to an authorized actual user. However, on 29th January 2026, a tanker bearing number GJ-27-TG-6676 loaded with 34.170 metric ton empty of spent HCl is departed from the petitioner's industrial unit, a factory, on 30th January 2026. Was found to have thrown that spent HCl in Narmada Canal. This prompted the Gujarat Pollution Control Board
Only for
take an action under section 33 capital A.
only one interruption, Lord. They gave me a show cause notice asking for a reply in 3 days, but without waiting for that, they closed me the next day.
We also closed, my lord, the other side. The other entity where they were receiving HCl, we found that they have not received HCl. What happens is, for them, it's a byproduct. For another company, it is a raw material.
But Lord, you also may say it's an allegation. I don't admit that he has done this, he has done that.
Pollution Control Board is said to have found from Messrs. Sri Ramnath Chemical
Yes.
that the spent HCl was not received by them. The spent HCl in a roasted truck was not received.
Lord, we dispute this proposition. We dispute this. That it was diverted or that, Lord, he didn't receive it. I dispute it. I'll show it.
Received by them. There is further allegation that it was thrown in Narmada Canal. Be that as it may, the Gujarat Pollution Control Board issued a show cause notice and thereafter has passed an order.
To show cause notice for 3 days, but
Lord, they did not wait for my reply. They passed the order the next day. That is one breach.
Invoked its powers under section 33 capital A of the water prevention. 33A2.
Yes.
Of the Water in Bracket Prevention and Control of Pollution Act 1974 and issue the closure order dated 3rd February 2026.
To avoid grave injury to the environment.
On the ground of avoiding grave injury to the environment. Next paragraph. The above stated order was challenged by the petitioner before the Gujarat High Court, before the High Court of Gujarat. However, the petitioner's petition has been dismissed by the High Court by the impugned judgment dated 5th February 2026 with the following liberty. Reproduced para 23. Next paragraph. The aggrieved petitioner is before us. At the outset, it is pointed out by Sri Mukul Rohtage, learned senior counsel for the petitioner, that in deference to the directions contained in deference to the liberty contained in para 23 above, the petitioner has filed a statutory appeal.
No, a representation.
Petitioner filed a reply to the show cause notice come representation.
No, actually, Lord, show cause is now over. I made a representation on 5th of February before GPCB, on 6th of February.
Has made a representation to the State Pollution Control Board seeking recall of.
Yes.
Revocation, well, it's called revocation. Revocation.
Revocation of the closure.
Seeking revocation of the closure order dated 3rd February 2026. That being so, we deem it appropriate to dispose of the special petition with the following directions, state liberties. One, the prescribed authority in Gujarat Pollution Control Board is directed to take an appropriate decision on the prayer or stroke interim stay made by the petitioner in its representation within a week. The interim order 2I, the interim order of any nature may be passed pending the final order on the representation, which may be decided. Do we need one order is sufficient?
No, dear Lordship, because that would mean that we have to pass some interim order.
Or not.
We will decide, but not finally one.
But for 1 week, please don't close it. That's all I'm saying.
To decide the representation within 1 week.
After giving me an opportunity,
After hearing an opportunity of being heard.
Personally, yes.
The petitioner's representative, authorized representative. Next paragraph. The aggrieved party shall be at liberty to approach the National Green Tribunal. There may be a separate prayer for control directions before the National Green Tribunal, and in that event, such a prayer of the aggrieved party shall be decided by the tribunal as early as possible and preferably within 2 weeks, subject to the pending appeal, subject to the outcome of the pending appeal.
Yes.
Please.
Yes.
Obliged.
Item 44.
Yeah, please, Your Lordship. Lordship, I've been in custody for around 269 days, and similar co-accused have been granted bail.
New Yorkers notice has not been issued so far.
Sorry.
Best matter.
Notice, no. Fresh.
You have granted bail to your co-accused, but then you have to issue notice in your.
That's correct, Your
Issue notice, trustee. Are you there?
I appear on advance notice, Your Lordship.
You are for the state.
Yes. Please.
Then say, Madam, accept notice on behalf of the state of Chhattisgarh. We have already released the co-accused.
Yes.
Do you want to file reply, or we can release him also?
We want to file a reply.
You want to file reply? Then do it by Friday. File a short reply. We have next Monday.
Oblige, Your Lordship.
counter affidavit with advance copy to petition post to
May I please, this is also fresh. Now 9 months, 9 years, 7 months, I have completed out of a term sentence of 10 years. Well, the High Court says that period of incarceration is not the sole criteria. Well, if I am going to complete the entire sentence while my appeal is pending, with great respect, my lords, it can't be that my appeal will be rendered infructuous as far as this is concerned. Please see the custody certificate, my lords, at page 446.
Well, your appeal is of 2020.
Yeah, my appeal is of 2020. Out of the sentence that is there, I have already undergone 9 years, 7 months. 10 years is the sentence that is imposed on me. 9 years, 7 months I have undergone. Another 5 months, 6 months I would have undergone the entire period of sentence. Entire period of 10 years I would have undergone. And the High Court says, my lords, that this is not the criteria.
7 years for 9 years. How can it?
7 years is actual, 7 years is actual, 6 months, 7 years, 6 months. Then they have added a remission period.
This is available in this kind of.
Remission is available.
Remission, it actually actual sentence only.
Is listed on 11th for hearing.
With respect.
Appeal is listed on 11th for hearing.
See, I'll go to decide why not an appeal for converting it to 302?
Because there is,
Huh?
I have filed an application
Yes.
regarding that.
But the victim has filed.
IVF, that's also pending.
That, Mr. David,
With respect, but today there is no appeal.
there is an appeal.
There is no appeal. Please see the cause title. There is no appeal, my lord. For there is. Please,
No.
my
We
learned
are not
friend-
concerned with cause titles, Mr. David. Is the victim here before us, who still has filed an
my lord,
appeal?
if there is an appeal, it would have been taken up with the same matter. Many.
But we don't wish to comment. Give the
Where is
number
the-
of the appeal to Mr. David, so that he is better advised.
I'm not. My lord, today,
Please, you get the number of the appeal under appearance.
which appeal, my lord, with great respect, there is no appeal in this matter.
Out of 10 years or so, whatever sentence that has been awarded by the trial court,
Yes, my lord.
you have undergone actual sentence of 7 years and 9 months or so,
Yes.
right? Less than 8 years.
Yes.
It's of 300.
It is highly debatable whether an offence involving moral turpitude of such a nature,
Yes, my lord.
will you be entitled to claim any remission?
Yes, my lord, of course.
Anyway,
You can claim
we
commission.
are not saying, we are saying highly debatable.
Because remission is available even in murder cases, but after 14 years, you have to undergo 14
Murder
actual
case
14.
can be, you see, murder case can be sometimes a simplicity murder.
This is a murder case
Two
only.
groups are fighting out of certain on momentary issues, sometimes without any intention, sometimes take place, or it can happen. There are several circumstances.
Remission policy of Delhi government is clear. This is a term sentence of 10 years.
Anyway, that issue becomes academic in this sense, once the learned solicitor is pointing out that your appeal is coming for hearing
On 11th.
on.
11th.
Yeah.
It was listed.
So we'll request the High Court, to take up your appeal on day-to-day basis. They are not opposing it, they will argue from their side. Prosecution will also extend full cooperation.
Victim's appeal.
No, this is, I'm with great respect.
And
I have yet to come across a case where a person has undergone out of 10 with remission, with remission also 7 years, without remission also 7 years.
Yes.
And that suspension is granted to him.
Mr. Dave, the total period undergone by a convict is undoubtedly a factor that is kept in view while suspending the sentence. But why we suspend the sentence? Only when we are uncertain about the time that will be taken in the final decision of an appeal. Here is a case where the main appeal has been listed for final hearing. What is only is required to doubt to remove any kind of cloud on that certainty, we will request the High Court.
It was listed on 3rd. As per the impugned order, it was listed on 3rd, not taken up on 3rd.
Why?
Because
Why must not have been taken up? Because somebody must have pointed out that your assent is coming before the
Nobody pointed it out.
There's a difference. There's a
No,
difference.
this is with respect, my lord.
Mr. Dave,
This
Mr.
goes to Article
Mr. Dave, right
21.
from all high courts in this country, including the Supreme Court, we have two categorization of two sets of criminal appeal before us, where the accused is on bail. We do not grant out of 10 hearing in those matters because we know that there is no crisis of liberty. Bail has been granted. But in these cases where we do not deem it appropriate to release an accused on bail, that's a separate set of category where the appeals are taken out of turn. If here is a case, 2020 appeal might not be ordinarily, it will not come as per turn in Delhi High Court, but because you are there you have not been granted bail, that's why the High Court is according you out of 10 hearing. And we will cement that, we will further request the High Court, making it sure that your appeal is heard.
It may be heard.
Lord, another
Well,
thing.
just 1 minute, my learned friend. Please just.
Undergoing a life imprisonment in the second offense.
So what difference does it make? So I should not get.
Here or not, Lord, doesn't make any difference.
Every time, the argument is even better. Now, please see if for a 10-year term sentence, suppose it was not 304 part 2, suppose it was 307, attempt to life 10 years I've got. Would it still be that I'm not entitled to remission?
We are not required to look into these aspects. We are not saying, you see, as an accused, you see, this is one country who is so proud of a rule of law that even the most heinous, dreaded criminals, we have been according opportunity of hearing. This country has followed the rule of law. This country has provided a fair trial even to the dreadest anti-nationalist elements, even terrorists. So even a person, as Solisly is pointing out, a person who came attacked so brutally on the integrity of this sovereignty of this country, we even provided fair trial to him also.
The offense was seen by the world on television.
What is my learned friend? I am not listening to the Kasab matter. I don't know why my learned friend is on Kasab.
In your case also, he is only illustratively telling that the worst case is also.
To Kasab, what do I have to do? I was a
You have to do nothing. You have to seek an assurance from the court of law that irrespective of the nature of allegations, irrespective of anything coming in media, you are entitled to a dispassionate hearing of your criminal appeal by the High Court, which will be decided without being influenced by here and there anything, which should strictly confine to the evidence on record, material on record. That's all.
So now, may I just answer one question which fell from my Lord Justice Bagchi. My learned friend says he has filed an appeal. That appeal is for necessarily enhancement of sentence. It can't be for anything else. It has to be enhancement of sentence or change, or that it goes under 302.
Why not? Why not? 302 charge was framed against you, 102. 300
against myself.
So there is a lesser offense on which you have been convicted. Why so to the?
Just bear with me for the submission.
Yes, you can bear with you for a lifetime, Mr. David.
The enhanced sentence could also be death in that.
May I just indicate why I am making this submission? If it is my learned friend's appeal, it goes to DB. This matter is before a single judge, it's below 10 life sentence, then it cannot, no, I'm saying if it is fixed on 11.
Appropriate cases, Mr. Dave, this sort of an appeal where there is a possibility of an appeal by the victim for enhancement, not a case for a division bench.
There's a point, for 11.
So nobody loses one.
Nobody is arguing this. I don't know why the solicitor has not preferred any appeal in this matter. The CBI is sitting pretty.
This is not a case of any quorum non-judice plea. These are all internal arrangements by the.
Are asking the High Court to expedite the appeal.
So therefore, in the case, suppose a division bench of the High Court, suppose prima facie feel that the appeal filed by the victim also should be heard along with your appeal. In that case, matter has to be listed before a two-judge bench.
So it can't be heard on the 11th in any case. Since much submissions were made, it's listed on 11th, hear it on 11th, have it on day to day. The other side is saying though, it can't be heard. That's what I'm all pointing at. The only thing I was pointing out.
Can be taken up on some.
So, Milords, 10 years, assuming that he goes through his 10-year sentence, Milords, his appeal would be infructuous. And if their appeal is dismissed, he's undergone the entire sentence.
Kind of whatever doubts you have in mind about listing, that we will clarify here. Both sides.
I'm saying, Milords, if
both sides are present before us, so
in 9 months, 7 months are not enough. If 9 months, 7 years are not enough.
As well as their.
We were not even charge sheeted for murder by the CBI. It was a club trial, therefore.
We are not charging.
May I just say, initial and third, this.
So I'm only saying, Milords, 9 years, 7 months undergone. With remission, another 5 months I have to undergo. I will undergo that period. There is nothing else that is left. Whether the appeal is heard or not becomes an academic question. Only if their appeal gets allowed.
Only no criminal appeal becomes an academic issue. Even in those cases where unfortunately the persons died while pending the criminal appeal. Because the family is still entitled to seek vindication of innocence. If there is an innocent person falsely or erroneously convicted by the trial court. So these are nothing to do completion of sentence, anything, these are not the circumstances.
Out of 10 years, 9 years, 7 months in custody or 7 years actual custody, it's more than 7 years.
I appreciate your contention, but then request the High Court, request the High Court to decide your appeal.
If I had come in any ordinary case, my lords, I would have got bail. With respect, I'm just saying so, my lords. When it came, the other matter came before your.
Jail for.
Just 1 minute, my solicitor is not, there is no notice is issued in this matter. Now, because that other matter, when it came, we said that this is, it fell from the Honorable Chief Justice that you are not released in that matter. Therefore, we are staying that matter, in the bail in that matter. When we come in this matter, the solicitor says, in that matter, you are in custody. So how does it matter? Somewhere I have to start getting bail, or I'm, my lords, going to be just in arguing my appeal or pursuing my appeal. And now the complaint.
We have already explained that in a case of conviction,
On merit.
and pending criminal appeal, what are the parameters normally we follow on uniform basis in all high courts and including the Supreme Court.
Yes.
Where the accused is inside and has not been released on bail, he or she is entitled to an out-of-turn hearing of the criminal appeal.
Yes, my
so that at least before completion of the sentence, the matter is heard.
My lord.
That is the principle followed. In your case also, there cannot be any exception. You are entitled to whatever you are entitled to in law, you must get it.
Yes.
Therefore, you are entitled to an out-of-turn hearing that the High Court is according. We will also make sure that you get it.
But that process is not available, my lords, because now the complainant feels that I should be convicted under 302. So his appeal first has to be.
Mr. Dave, for deciding your.
EC 365.
For deciding your appeal, we cannot get the right of a victim. If at all there is a right in law.
Mine also, my lord.
Yes, therefore balancing has to be done.
For 9 years, 7 months.
We are absolutely right to do that. There has to be a balance of rights.
I've undergone more than half of this actual sentence. Actually, I've undergone more than half, my lords. Kindly consider this. In which case, for term sentence, this is not a life imprisonment. Life imprisonment, I can understand the High Court has some leeway. Your lordships may have some leeway that it's a life sentence. There is no term there. But in a term sentence, my lords, your lordship always takes into account the period.
It is a term sentence of a person who has been convicted and sentenced to life imprisonment in another case.
Yes, my lord.
Isn't that a relevant consideration for
When
suspension?
that matter came up, my lords, the same argument was there that please stay.
One will follow the other.
So, my lord,
If there are, why do we speak of criminal antecedent? When it comes to a question of multiple cases against an individual, courts are generally circumspect in granting pre-conviction bail.
Same incident. It is not a separate.
No, it's definitely not the same incident.
Exactly.
It's the motive.
Incident.
It's the motive.
Allow me to.
The rape case is the motive for this crime.
In this case, here the person died in police custody. Person died in police custody.
Police officers have been convicted.
Yes, my lord. Then I have been with 120B. I was in Delhi. Those are the findings. I can show.
Let us not comment on the merits.
Any argument touching the merits from your side will invite a reaction from our side unnecessarily. And you know this matter that unfortunately it's not that we are not sitting in ivory tower. We know that there is a media trial also going on, which we do not really approve. And the way Mr. Prachap outside the court, he goes to the media. If you are a counsel, you have no business to go there. Don't forget, I have saved you in profession. Your license would have been suspended. Your exemplary costs were imposed on you by the High Court. I saved you thinking that you will believe in professional ethics. You have no business to go to media when you are appearing in a case here. And if you find that you are indulging in this kind of drama, then you will face the consequences also.
Can I just say?
As a Chief Justice of India, I can't tolerate these things.
Let's kindly see what the other side.
You are arguing here, you are conducting a parallel trial outside the court. This is not acceptable. We are only warning you today to take this warning in the right earnest. That's all.
Is that please tell this to the other side
Right
also.
on.
What they have decided, I never went and gave interview in the
Now,
other side.
we have conveyed our message, and anybody knowing that how I function, I hope that people will believe it and follow it.
So then may I only suggest.
Do not invite any
Let
consequence.
the
That's
DB
all.
take a call whether his appeal is maintainable or let the DB.
Other side also.
You have the right to oppose, you have the right to
No,
argue.
I'm saying let the.
You will argue in court. That's all.
Because the division bench, since your lordships are asking for expeditious, let the DB first decide whether his appeal is any merit in it or not. Then call for his appeal.
The way that you will argue before division bench of the High
Leave
Court,
that.
not before us.
Expedite, then I'm only praying, don't expedite this simpliciter, my lords, my matter. Because it will be tied up with the division bench matter.
that the petitioner shall be granted. The appellant is agreed by an order dated 19th January 2026, passed by the High Court of Delhi, declining his prayer for suspension of sentence and consequently the release on bail in criminal CRLA number 539/2020. The declining his application done, application under section 389 in bracket 3 CRPC, seeking suspension of sentence and so on. The above stated criminal appeal has been directed against a judgment dated 4th March 2020 of the trial court, while which the appellant was convicted for offences under sections 166, 167, 193, 201, 203, stroke 21, stroke 21, 212, stroke 323, 341, 304, 120 capital B IPC, and sections 3 stroke 25 of the Arms Act. We just make sure that correction in this section. He was consequently sentenced to undergo a rigorous imprisonment of 10 years.
Yes, my
10
lord.
years.
Highest is 10 years amongst all of them. The highest sentence amongst all of them is 10 years.
Terms, maximum of which was
A maximum tenure of, maximum RI for 10 years, though different sentences were awarded for different offences. Those separate sentences were awarded for different sentences, offences.
And all directed to run concurrently, my lord.
That's what it seems that the appellant, besides arguing, besides making an attempt, a case for suspension of sentence and release of bail on merits, also vehemently urged before the High Court that he has already undergone an actual sentence of 7 years and 9 months out of the total sentence.
With remissions. With remissions.
7 years, 6 months, 29 days with actual. My learned friend is not aware since I'm in custody, and 9 years, 7 months with remission. So 7 years and 7 years and 7 months of actual custody.
7 years or 7 months of actual sentence. Anyway, that's a matter of calculation.
No, it's there, my lord, at page 46.
The High Court has, by the impugned order, one more line. The appellant also has that some of his co-accused had already been released on bail after suspending their sentence, while orders dated 22nd September 2023 and 17th October 2023. The High Court, however, while the impugned order has declined the suspension of sentence and consequential release on bail, internally observing that the appellant is already serving a life sentence for the rape of the deceased minor daughter in a connected case, semicolon, that his previous application for suspension of sentence was dismissed on 7th June 2024, and there are no new exceptional or compelling circumstances, etc., etc. Next paragraph. The agreed appellant is before us. Next paragraph. At the outset, it is pointed out by Sri Tushar Mehta, Learned Solicitor of India, representing the Central Bureau of Investigation, that criminal appeal, criminal LA number 539/2020 of that the appellant's criminal LA number so and so is now listed for hearing before the High Court on, what is the date, otherwise?
11th.
On 11th February 2026. He thus submits that the High Court can be requested to take up that appeal, to take up and decide that appeal on out of turn basis. Can be requested to take up and decide that appeal on merits from on out of turn basis. Next paragraph. At this juncture, counsel for the victim states that the complainant side has also filed an appeal challenging the trial court judgment dated 4th March 2020 on various grounds, including on the question of quantum of sentence. Next paragraph.
Which is pending before the division bench.
Since there is no reference to that appeal in the included order of the High Court, we do not express any opinion in relation thereto. Next paragraph. Keeping all the attending circumstances of the case, especially the period of sentence already undergone by the appellant, we deem it a fit case for requesting the High Court to accord out of turn hearing in criminal LA number 539 of 2020 and decide the same as early as possible, but not later than 3 months. But not later than 3 months. Next paragraph. As regard to the criminal appeal, if any, filed by the complainant party stroke victim, we grant liberty to the appellant in that case to approach the High Court for taking up of that appeal to for hearing. The High Court is requested to firstly take up that matter within 1 week and subject to the objections maintainability, etc. If the High Court finds that the said appeal to issues can be decided together, then maintainability, etc. It will be in the interest of justice that both the appeals are heard and decided together. Heard and decided together. If such a recourse requires the change in composition of bench for deciding criminal LA number 539 of stroke 2020, Honorable Chief Justice of the High Court will do the needful in this regard. Anything else you want?
There are 8 connected appeals which have to be decided with this 539 of 2020. They are all co-accused. So it's not my appeal. There are 8 connected appeals.
Connected appeal of other
It's 539 of 2020, the present appeal. So they all have to be decided together.
If there are, next paragraph, if there are other connected appeals, those two also be taken up and decided along with the lead appeal, along with the lead case.
Then if it is not decided in 3 months, then where do I go?
Yeah.
So then I'll be back for.
Incidentally, I am not retiring in 3 months. My brother or both in any case will retire after marriage. So there nothing is that unforeseen circumstance we should see.
I hope, my lords, I will be back before your lordships. Grateful.
Lord, the bail matter. That's the also.
Also notice.
Accepting.
Advance.
Would you like to accept notice?
Accepting.
Then say accept notice. Counter affidavit can be filed within 1 week. Counter affidavit for 10 days.
2 weeks.
2 weeks. 2 weeks post the matter on so date for further consideration.
Get me that.
question is being made. Extra
23.
Any comment? Which is full of Lordship, it's specifically refer for the.
This writ is not maintainable. Kindly have the prayers, my lord. If he has a grievance, then he can approach the High Court, my lord.
Uniform standard operating procedure governing freezing.
And that is already on.
The accounts during cyber crime investigation. How can such a direction be issued? Sir?
Lordship, the thing is, after the last
It has to
order.
be decided on case-to-case basis.
Lordship.
Where we find that yes, freezing is absolutely unwarranted, we can go, the court can interfere, and that why should we entertain this?
Lordship, there is a subsequent development after filing of this order on the 16th January of the last order. Delhi High Court also issued this similar.
That matter is also today.
That's a suo motu petition.
No, is it listed today?
Yes.
Okay. We'll hear it up here.
Yes. Lordship, just consider the order passed by the Delhi High Court in a similar matter, where the Home Ministry come with the standard, they've already issued some SOP. So if SOP is there, then just let it be.
High Court of Delhi High Court judgment before.
My lord, I am also in the matter 47, similar matter, my lord.
And then one more part.
Judicial High Court is UP, my lord, Allahabad High Court.
My lord, these accounts are being frozen across the country, my lord, and there are so many matters.
Because.
And there is urgent need, my lord, to intervene and
You
to.
want us to uphold this freezing of accounts? You want
No,
us
my
to
lord,
uphold?
I am saying
Don't invite
unfreezing
forgettable.
should be a mechanism, and the 106 is being violated, 107 is being violated. Magistrate order is required, my lord.
Having heard unconstitutional.
Kindly issue notice in this matter. This is very urgent, my lord.
Judicial Association of India on behalf of the respondents, Union of India, we see no ground to entertain these petitions.
Multiple states are doing in the same account, my lord.
Accordingly dismissed, however, with liberty to the aggrieved persons to approach the jurisdictional high courts on case-to-case basis.
Lordship, before concluding my. I just want to point out one thing.
Yeah, everything coming under 32. As if there is no other.
This is being misused by the law enforcement authorities quite a bit.
Absolutely.
Kindly, it is required, my lord,
that they must do something very.
I am in Mumbai. My account is frozen for 4,000 rupees from Jammu Kashmir, my lord.
Then go to High Court, approach the High Court.
So that's the concern of the entire petition, that if I'm standing in.
There has to be proportionality, my lord.
Complaint filed before.
Every person like this start coming in the 32, what will be the end?
More than multiple states involved, my lord's intervention and the law has to be settled, my lord.
Yeah, don't worry, we will do that. We are right now.
Kindly issue notice and allow us some relief, my lord.
Question of issuing notice in these matters. where you are suspected to be involved, where is the question of issuing guidance for your instance?
47, this is my customer, it's a consumer matter only, 4,000 rupees.
Yeah, thank you very much, thank you.
Kindly have a look at page 60. Just 1 second, my lord.
Not see anything, please go to High Court and show.
It will be,
Go
no,
to High
my
Court
lord,
and-
can give, just see my customer is there.
Yes, yes.
And they are misusing this. After 8 days, they are filing this complaint.
Sir, the banks are hands in glove. This is what the report shows. We don't want to say anything because it will cause serious prejudice to all of you. The banks, their officers are hands in glove in the matter of digital arrest and the cyber crime of looting this money. It's not extortion, it's a
My lord, but I am suffering.
brazen loot.
Yes, Lordship.
Bank might be involved, but I am suffering, my lord.
Lordship is absolutely right.
But
There is
then
a
we
bank
will-
are involved, but in this case, those are not directly compared.
No, please go to, that's why we said case to case basis. If you are a victim, you will tell the court. If you are clean hand, you will tell the court that I have nothing to do with, court will pass an order.
We are not concerned with the transaction itself.
Thank you very much, thank you.
Lord, there is no FIR, nothing, just the misuse of the I4C mechanism.
Yes, yes.
Kindly issue some guidelines on this for the defreezing, my lord.
We will not issue right now, we will see at the time of final hearing.
And my entire business is gone, my lord, because my account is completely frozen, my lord. I am a small time professional operating out of Mumbai, registered with SEBI,
Yes,
my lord.
item 24. Lunch. Yeah.
May I request that 24 may be stood over?
That would be the no.
No, may I request that 24 may be stood over to tomorrow or any other date? There was some misunderstanding. I thought this was the matter when notice had been issued and
Next Monday, Mr. Singh.
there was some miscommunication on my part. Can I request your lordship?
No, you wanted to place on the additional document.
Please close, but I thought this was the matter when notice was issued. I mixed it up because no reply was there in that matter. So if your lordship could keep it either tomorrow or Friday, or whichever date your lordships.
Friday, we are avoiding Friday.
Or Monday, there was just some miscommunication on my part.
Want to next Monday we can take.
We've already filed the documents. I had some misunderstanding about which matters listed.
We will say like this.
Monday, if your lordship would keep it.
Mr. Singh and Senior Counsel informed that additional documents have been filed. They registered directly to tag the same, post the matter for further consideration on Monday.
Deeply blessed.
ट्रांसफर करना है
May it please, ma'am.
Item 26.
26, your lordships have already.
We have allowed that matters.
Despite your lordship's order, every day they are filing
They are
cases.
still filing. Then if we issue notice and you remind us, then we'll impose some exemplary post.
I'm grateful, my lords.
How much the amount in dispute?
My lords, the loan amount was 1 crore, out of which we went to DRT and we paid substantial amount.
Issue notice to the respondent, returnable on so and so date. The respondent bank will also show cause as to why contempt of court proceeding and exemplary fine post be not imposed on it for filing complaints at. The complaint has at which place?
My lords, Calcutta, my lords. Calcutta.
Has been for filing the complaint at Kolkata instead of Nampalli, Hyderabad.
Correct.
Basti.
Till then the proceedings may be stayed, my lords. Till then the proceedings may be stayed, my lords.
You said them next week. What is the next date?
My lords, the next date I have to verify, my lords. I have to verify.
Meanwhile, further proceeding before Calcutta and social remain state.
I'll do that, service, my lords.
Bengal ऐसा है
Item 48.
Grateful.
Yes, my lord.
Oh.
May it please your lordships.
We will take up along with those matters. We will take up along with other matters. Everybody shall now start filing separate cases. Take up along with the other case. Coming 2 o'clock.
Minute.
One matter, my lord speaks today as item number 36, where the Calcutta High Court directed the tribunal.
Wait for this.
Can you take up this matter at any point of
We
time?
will see, we'll see.
Yes.
Item 39 first, digital arrest matter.
You please, your lordships. I have got a brief note of lordships consideration.
Yes.
Just to give a status report on that, an update. We also hand over the complete status report.
Threshold of 10 crore may be on the higher side, Learned Attorney. Individual losses, I mean, the individual loss of 10 crore.
Yes. But then,
But then, see, there are people, senior citizens, for them, any amount of running into few lakhs, particularly in a case like one of the retiree, a couple, where which prompted us to take suo moto. There the loss was 1 crore something.
That's right.
But so look at that, for them the entire life saving.
that's true. Nobody has any, but the government is very keen. We should put all these schemes in an, action mode as early as possible. But unless we complete this exercise, it will be like working in darkness. So I think
As per the initiative, we appreciate. That's it.
the SOP in fact is very exhaustive. And there are some Rajasthan High Court and Kerala High Court, some judgments have come. We are trying to look into them. As far as they can add on to the SOP, we'll try to add on to them. But I don't.
You can apprise us if the high courts are also entertaining. We don't want any parallel proceeding to come.
That's true. That's right.
That we can transfer those.
So the SOP as of now, I think is fairly comprehensive. And let it take shape by giving, putting it in action mode. And therefore, your lordship will kindly, in terms of the status report, kindly turn to page number 9 of the status report,
Oh.
As of now, I think in view of the progress being made, this limited direction would suffice. I had a word with the General Amicus, and we value her inputs being given to the government, and she will continue to be associated with the deliberation. So page 9.
That's it.
This will go a long way in now trying to expedite the entire process of deliberations. There's also, I think, since I suppose the Lord Amicus would share her views with me, and we'll try to, I said, add quality by adding her inputs into that.
My lords, I have filed a written submission pursuant to the status report. I've tabulated, there are two status reports that were filed, one by MHA and the other by MATI. The first one being of 13/1/2026 and the second of 29/1/2026. I have tabulated it and I have shown what are still pending and that which has been addressed at least at a preliminary stage. And we will, I'll continue to, I'm hoping that there will be cooperation from all the departments because, my lords, the status as it stands today and from the status report also is that every action that has been mandated or warranted by my lord's directions or as suggestions from all the stakeholders collated and submitted along with my suggestions are work in progress. So they have pointed to some of the actions already taken under various circulars, but there is not yet further action or suggestions on what is to be done next.
I think if the SOP is approved, then
The SOP is a
This
critical.
note,
Yes.
this note summarizes, I think, the ongoing deliberations and the time frame within which, kindly, if you lot kindly turn to in the two-page note, there are 2 or 3 things which are essential before you go further. For instance, E. We have A, B, C, D, E. So RDV has drafted the SOP. Then E, Department of Telecommunications drafted the telecommunications user identification rules.
I think all the departments are now in action.
So these are all very important.
Well, all of them have come on board. RBI has still to have a meeting. They have not yet had deliberations with
SOP
me.
is by RBI.
They have mentioned it, but I have.
That's right. And now it's been finalized now. The SOP has been.
The only SOP I have is from I4C, which was prepared pursuant to the Chhattisgarh High Court's order. But that was also a preliminary stage and it has not yet been submitted before.
Not that this SOP, because the action is the essence of this entire, this to deal with this crime effectively. So we issued the directions to implement the SOP immediately. Meanwhile, you critically examine that is there any lacuna or vacuum left. Then we will request them to address that.
Very fairly, I would say, reached out and requested me to be part of the delegation. It would be my
That's very fair.
duty to contribute. I will be most happy. Manoj, I would only want to put this first, and it's recorded in the meeting also, which I had attended. This is a consensus mediated process. And all the departments are coming on board, keeping that in mind. There have been extensive discussions, they have been cooperating, but the only thing that I have requested, and that's what my note encapsulates, and that is that the action that needs to be taken pursuant to some of the lacunae having been pointed out, that still remains to be done, and some timeline may be fixed by which they will do that action. And that would also help us to then
Timeline for
the departments to revert